We thereafter filed another petition, civil number 130/2024, again on the same set of facts. Where he was advised about the legal position that the issues sought to be raised do not fall within the domain of judicial review. He consequently withdrew that petition to approach the appropriate court. Next, the incorrigible petitioner has again filed this third writ petition purportedly in public interest. This time also, the foundational facts are identical. It seems to us that the petitioner is an intermeddler who indulges in this kind of petitions to gain popularity. The factual issues sought to be raised are difficult to be determined on judicial side. No case to entertain this petition made out, dismissed. Next, where the registry directed not to entertain any petition that may be filed by the petitioner claiming to be in public interest. जाइए नहीं तो और कोर्स लगा देंगे आपको.
To withdraw the matter, my lords. Similar matter has also been withdrawn. 25 minutes.
हो गया था. Item 26. Just the next week can do next week will be. I mean, Ashwarya normally appear open daily. Municipal corporation.
My lords, after filing of this petition, we have been informed that the Union of India has already notified the constitution of the appellate tribunal for India.
In that case, na, in fact, they must have, because in the earlier, there are another matter pending before us, where we had, I was reflecting. So this must be now effectual. You are for hak nahi.
Yes, my lord.
Hold it. You are rightly pointing out, because there was another matter before us regarding the illegal construction in Chandni Chowk area. There probably it was pointed out by some counsel that the appellate tribunal is not functional. Then we directed the union and NCT to find out, and they informed us that they have notified. So the petitioner, you are in person.
Oh, no, my lords, it's been filed by NUR.
Okay, okay. And counsel for the petitioner at the outset states that the appellate tribunal has since been notified under the appellate tribunal under the NDMC Act 1994 has since been notified for rendering this petition forward.
Great, my lords.
Item 27. इसमें कोई नोटिस नहीं simply tag कर दिया.
May it please my lords, political parties across the spectrum have engaged in accelerating arms race.
There are already petitions, sir. You can assist us in that matter.
My lord, in Bengal election, the promises are there, my lords.
Item 28. Suit for partition law.
Your Lordship, I am for the defendants. The defendants has also filed a counterclaim seeking their share along with the requisite court fees. 2014, the suit was preferred. In 24, they have filed a withdrawal of the suit on the grounds that certain properties are gifted or were self-acquired and cannot be partitioned in.
Okay, amendment of pleading, no? You are asking for withdrawal, use order 6 rule 16, amendment of pleading.
My lord, what has happened is the petitioner's number 1 and the grandfather's name and the wife happens to be the same. So when they are collating the schedule, a number of
You understand, some property which are personal properties were made a part of the schedule for the partition suit.
yes, my lord.
So for that, do you need to withdraw the partition suit? You can make an application on order 6 rule 16
This
for
mistake,
amendment of the schedule.
at this confusion which you are pointing out, you can clarify in the
It's
amendment.
much easier rather than withdrawal and look at it. Their
It is
problem.
in your
They've
interest.
already filed a counterclaim.
My lord, in fact, the trial is yet to begin.
Whatever.
Yes.
Why you are?
It will save your time also. It will give an opportunity to clarify everything, whatever confusion, factual issues, you can amend the amended petition. We'll right now permit you. It will save your time, both sides.
Easy. Why should you unnecessarily go for withdrawal again file?
So.
Just amend the
notice, accept
schedule.
notice,
Oh, my lord. My lordship may give me liberty.
and say hard line counsel for the parties. Say leave granted.
But in fact, my lord, one decision of this
Towards
court
that-
says with
Get decision. In the facts, what is most convenient?
It seems to us that.
Procedural law should be handmaiden of justice, not subtle justice.
It seems to us that in the particular facts and circumstances of this case, from the learned High Court, instead of allowing the respondents, contesting respondents to withdraw the suit, ought to have permitted them to invoke order 6 rule 16 CPC and seek amendment thereof. Also, we say so for the reason that meanwhile, the appellants have filed a counter claim along with the requisite court fee. That's, which survives for rectification. So, in these circumstances, without expressing any opinion on rights, the appeal is allowed, the informed order of the High Court, so and so is satisfied. However, the respondents are permitted to amend the suit under order 6 rule 16 CPC. So let such amended suit be filed within 4 weeks.
yes, my lord.
Within 4 weeks, the civil court shall proceed with the amended suit along with counter claim in accordance with law.
Oh, my lord.
These are matters. We attach the notice करके SLK civil number 30494 2025 delay है तो delay के लिए कर दें. 30
It's in 30. We're requesting the same order, which is at page 230, 231, except there was a mistake which I made last time. I indicated that it was 45 years late. Actually, it was an arithmetical error on my part. It was 35 years late.
92.
Yeah,
92 was the earlier suit.
yeah. So the same order at page 230, except with the correction which I request, 35. Manoj, I have, for the court master, I have a list of the,
but I think here is mentioned 1992.
It's not 45 which I have, it was 35.
corresponding diary numbers of the SLP and the original suit numbers which may be put in the orders.
Start with SLK number 1 so 20. they require interim order also.
Stay.
Yes, meanwhile, interim order.
Even this.
What is 45 is mentioned? So, dated 18th February 2026. Passed in SLP Civil Diary number 185/2026 is ordered to be corrected to the extent that last line of para 2 shall now be read as follows. The same is challenged after 35 years, purportedly on the basis of legal advice to OS number 237/2022.
Your lordships are passing the same orders with the.
Same order we have corrected that order.
Yes, and it may be tagged. And also the stay of the corresponding suits.
Can stay same terms we have.
Yes, same term, but the suit numbers will change, which is what I handed over. Because there were 6 separate suits. Grateful.
Item 31.
Yes, my lord. My lord's recrimination petition was filed. Now, unfortunately, my lord, the recrimination petitioner dies. The High Court, my lord, the net effect, my lords, is this. The recrimination, my lords, does not abate. Now, the High Court in the previous order had said that has closed, there is no right to give evidence. We came before your lordships. Your lordship said correct, others can't come and implead themselves, but the contesting respondents can give evidence. We go before the High Court. High Court now says, my lords, the recrimination has gone. Therefore, there is no pleadings by you because I am not the recrimination petitioner. Because although I am a contesting respondent, because you have no pleadings, you don't record evidence. My lords, the net result is this. Whether I win or lose, my lords, I am out. His prayer is he should be declared as a winner. Now that will go unchallenged, my lords. I have evidence to show that if I have paid money and corrupt practice, he has done the same thing.
You cannot need evidence of recrimination facts which are not pleaded by you. What you can do is use your tool of cross-examination to the extent possible. It is something like a suit where written statement is struck off.
Correct, my lords. My lords.
Right? When a written statement is struck off, you cannot lead an independent evidence, but you can always improbabilize the plaintiff's case.
My lords.
To the extent he is seeking election, it is his suit where you have not filed a written statement in the form of a recrimination.
Yes, sir.
The deceased respondent had.
Correct.
In this situation, what you can do is improbabilize his case through cross-examination, but we cannot permit you to lead evidence, right?
My lords, I sought that liberty. May I just make one submission, my lords, if it.
Because what we find erroneous in the order is the judge goes one step ahead by saying that you cannot cross-examine also. That perhaps the judge is not.
That should go, my lords. And may I make
But
one other?
not lead evidence.
My lords, I have produced with an IA an order of 13-1on the ground that there is corrupt practice.
In para 5 of the previous order,
Please, my lords.
we have said as regard to the observation made by the High Court in paragraph 16 of the incident order, the other contesting candidates will be at liberty to avail that remedy in accordance with law.
My lords, that is your lordship's liberty.
Where he is saying.
My
that
lords,
the
paragraph 19 is my
order of the
contentions.
Supreme Court
is wrong, that he can't even cross-examine.
It's qualified by on recrimination. On recrimination.
No, on recrimination also you can
Also-
cross-examine, sir.
Sir.
Because you are to prove you are eligible for being elected. So in that situation, if we can cross-examine you without leading independent evidence, how can we shut that door?
Pleadings ought to be there.
Not necessary, not necessary. For that, leading is done. We can clarify that, you can cross-examine on it.
My lords, if that
You
clarifies,
cannot put in independent.
I understand, my lords. I cannot, my lords, adduce fresh evidence and put an independent.
Like you cannot confront him with a document saying that you have paid money to X, Y,
I understand.
but you can always cross-examine. If he admits to payment of money, what will happen?
My lords, in fact, there's material, I'm sorry,
And-
I'm so sorry. There's material available on record, my lord. I
Yes.
have to just confront the witness, my
They ought
lord.
to have filed recrimination in time. They have not done so. Having not done so, as my lord rightly pointed out, to the extent of examining cross-examination, but there has to be
Again,
some.
we are
pleadings to that
trying to
effect, and-
indicate to you. When
Only on
a
that basis-
plaintiff seeks a relief,
Please.
it is for the plaintiff to prove all causative facts which constitute cause of action for relief.
For the person responding.
Not for the person, for the relief. I mean, when a written statement is not filed, it takes away the right of defense. But it doesn't take away the right to improbabilize the existence of all necessary ingredients to make good the relief. So in that
His written
respect,
statement
Mr.
is not
Pogaya's
taken up
client
any
cannot,
contentions regarding-
cannot
Denied the cross-examination.
deny cross-examination, sir.
In his written statement, he has not taken up any right, any
Again, we are
contentions with
saying,
regard to my.
forget,
innocence.
we are looking at a example where his written statement is struck off. Correct? No written statement.
It is not there on record. Even
Does it mean the plaintiff will get a decree on non-traverse? That is not so.
Subject to that liberty, my lords, I may be sent back, my lords. I'll finish the trial.
No, what is the- We have heard its decision, we will learn from counsel on behalf of the appellant and counsel on behalf of the respondent.
Number one. Respond number one. my lord. Someone give it for respond number one.
It is true that in terms of the previous order dated 15th December 2025, passed by this court in SLP Civil Diary number 67667/2025, the appellant is not entitled to file his own incrimination petition. However, that fact in itself cannot deprive him to cross-examine the witnesses on recrimination. Recrimination. That's you have filed a petition
Yes, I am the election.
on the recrimination claim of respondent number one. With respect to the claim of recrimination raised by respondent number one. So that means so, from para 19 of the improved order passed by the High Court dated 10th February 2026 is modified. And the appellant is permitted to cross-examine the witnesses that may be produced by respondent number one in support of his claim of recrimination.
I'm very grateful, my lords.
The improved order stands modified to the extent of that.
Obliged.
Grateful, my lords.
These are also matters pending already.
Yes, sir.
Issue
Can be tagged along. Can be posted on the 13th May along with the.
yes, tag me to add.
Referring to all the journalists.
Yes, yes, there is a date in our.
On 13/5, your lordship, the other matters. Obliged.
Your lordships, if you could have 33 with 37, because it's a super tech project. So my lords, at 37, the main matter has been listed.
Your lordship, this application is entirely on a different ground. This application is on a ground of an impugned order, Your Lordship, which has been passed for giving a maintenance to the association, which is within the right of Section 14, Subclause 2 of UP
No,
Apartment
that
Act.
association, the issue is only of association.
Yes, Your Lordship.
Who has formed that association? How many allottees are there?
Right,
How
Your
many home buyers are there?
Right, Your Lordship. Your Lordship, that has already done in the impugned order, Your Lordship. Now they are claiming that they have filed one application.
Mr. Jain, Mr. Rajiv Jain, this is also a matter of this. This is also Supertech, no?
Yes, pavilion, 34 pavilion, a super type project.
The Supertech 34 pavilion. I think this is also one of those projects. Now NCLT has handed over this maintenance and every activity to the association. They are home buyers.
No, Your Lordship.
Well, the project was completed in 2012 itself, Your Lordship, minus the registration, everything has been actually handed over as far as 34 pavilion is concerned. I pay for the home buyers that's there. Now, any other agency coming trying to take over, it will only create more complications. Otherwise, minus the registration, portion has been handed over. The entire formalities has been
How are
completed.
we concerned about handed over or not handed over? We will pass an order, that's all.
Your Lordship, I am representing the association. He does not have a locus, Your Lordship. He's claiming that I am one of the allottee. But as of now, he does not own any flat there, Your Lordship.
Therefore, we would like to ask the learned amicus to submit a report to us that how many members, home buyers are opposing this handing over to the association. Mostly these associations are nothing but the masqueraders of the builder themselves. Most of the they only take care of what's their interest. So just we want to find out that factual inquiry.
38 flats, Your Lordship, all of them have been handed over. 138 flats, Your Lordship.
My lord, only that handed over with what?
It's not only that, in fact, the project is complete itself in 2012, Your Lordship.
Set aside that handing over if you are satisfied.
My Lordship, no, the project itself was completed in 2012 itself.
2012, you must have handed
Somebody needs to have a grievance towards that. My difficulty is as of now, the whole process is complete, handing over is complete, let's say residents are there. RWA is formed, Your Lordships. RWA is already in existence.
This order we are already.
There's RWA which is already in existence.
Your Lordship, only one submission.
Just hand over the petition to Mr. Jain and let us verify the fact.
Your Lordship, only one submission for this, Your Lordship. Your Lordship, similar petition, similar application was filed in one of the project Supernova, Your Lordship, where the YG estate, who is the sister concern, Your Lordship came and Your Lordship has set aside and asked them to withdraw the appeal, Your Lordship. Now, today what they are doing is that through one of their person, Your Lordship, they are filing this application, asking the similar.
You are saying one person. He is saying all the home buyers.
No, Your Lordship.
You see what we want to know.
There is no application for that. He is the one allottee who does not own the flat also.
My lords, I have no objection to Mr. Jain looking into this matter.
Yes, please.
Because all I'm saying is that the
And over the copy to you, give the list of your association.
My lords, may I only make one? Let Mr. Jain inquire.
One by one, let them tell that whether they are members of the association, the apartment is allotted to them.
We will do that.
Let them prove their
My
documents.
lords, may also direct, my lords, there was an application for upcountry of Supertech only. My lords has passed now an order on 10th of April. Yesterday, my application was listed, I'm sorry, on Friday. The Honorable NCLAT has not decided and has simply said that the Honorable.
Concern in this matter, please.
My lord, this is
Wait
the
for
same.
the main case.
My lord, this is on the maintenance handover.
Lords, may.
The NCLAT is not entertaining any.
We'll take up with 30, so.
Very well.
Meanwhile, give a complete set of the papers. Item 34.
Please, Lordship. Lord, this is a writ petition challenging the order of the High Court dismissing the.
Delimitation, actually, even if delimitation or no delimitation, even if correction, these are all statutory power.
Lordship, may just see the notification P6. P6 has got 200 blanks. Lordship, may just see the notification.
The only embargo can be that if suppose it is done only to delay the election, to preempt the election. That is not the case here.
The election has not been announced so far. Lordship, may just see P6. Lordship, may just see P6. P6
If you have any supporter with you, then go and contest in election.
There's no supporter in this matter. It's just titled in a different way. It's just P6, Your Lordship may see, 200 blank spaces.
He is more
Everywhere it says-
emphasizing on that I'm president of so-and-so political party. Go and contest the election.
Lord, that
Save your deposit.
he may do or may not do, that's his prerogative, Lord. Your Lordship may just see, each street, there is a blank. About 230 some blanks. So how do I file objections?
Municipal Council office, the
I'll
filled
just
up
come
blanks
to
were
that.
there.
I'll come to that. That map is lying there. That map has no wards, no delimitation, no legend, nothing. It's a letter. Your Lordship would know how the maps are there. They are on a piece of cloth. They are put there and there's nothing there. And that's what I've said. Now the court
Be
says,
that as it may, objections were made.
yes, Lord,
Have
objection.
been duly considered also.
But
There were two
no,
things.
Lord, with due
Short
respect,
Short time, 7 days.
there is nothing on record, even either in the notification or in the reply, that the objections were decided. And what was the decision? No decision taken. I may not have a right to challenge it, but I have a right to at least know what are the objections, how have they been decided. There's nothing here on record. The High Court says the government can do whatever it likes. It's its wish. You have got no right, no principles of natural justice. As far as
The High Court simply said these are the matters basically taken as statutory exercise. Only
not-
to
I-
address
I am-
certain
I am
areas
not-
and to ensure balancing.
I'm not contesting that. But once you give me a right to file objections, I'm entitled, I may not be entitled to a hearing. Because of course, if there are thousands of objections, it'll be almost impossible.
Your individual objections have been considered. You are only carrying, you just want to create for yourself a political mileage out of it. That's all.
With due respect, Your Lordship, see the P6. P6, nobody deals with it. High Court also doesn't deal with it. In fact, the High Court warns them that next time don't do this. Instead of saying that, how have you done this? But 200 blank spaces, how do I file objections?
That the High Court has taken care of, saying
No,
that there was no prejudice because you filed the objection.
And Lordship may see my
Two
objections.
things.
My
High Court
objections
said
are.
that it was with the Municipal Council office.
Yes, sir.
We understand you have taken a stance that it is not exactly
Yes.
in the form in which the notification should be there. But nonetheless, finally, the High Court holds that this deviation, which as you rightly say, the High Court indicates should not have been done, did not deter the writ petitioners from filing objections.
Yes, sir.
And the objections were considered. Legislative exercise, reasons and hearing will not be attracted. And final delimitation, if necessary, can be challenged, although in very limited areas.
Challenge the
The only
delimitation.
other matter, the judgment should have been in 3 pages. The judgment should have been in 3 pages. ये हमारे great Sethi साहब पता नहीं unreported judgment 62, 66 के कहाँ से निकाल के
Even those judgments don't say what has been said. Even those judgments don't say what has been said.
God knows where from, who has cited him, why he has referred to all this.
So my only simple.
Why the High Court judges are, they should state their own principle of law. Keep on citing this, unreported orders 1962, 1954. Thank God he has not gone beyond 1947.
And those are all against me, Milord. Those are all held against me. Those unreported judgments, all held
He
against.
should have simply rejected outrightly.
He should have simply
In 3
rejected
pages.
by saying not entitled. But once he says, goes into the question of consideration, then I'm at least entitled to the copy of the order. There is no order. My instructions are not, there's no order. Normally what happens is when the notification comes, it's written, objections considered and decided. Lordship may see the notification. Nothing there.
Good enough, good enough. Be ready for election, that's all.
As your Lordship pleases. I won't trouble your Lordship anymore.
Thank you, thank you. Yes, item 35. Oh, election, no, Prashant Kapil.
Please.
Followed on 1st of April, an intervention application filed by the petitioner was listed before Nagpur bench, and in that order, the Nagpur bench has overlooked the judgment of this honorable court, that is SCBA versus BD Kaushik, wherein one bar, one vote was made a principle, and wherein it was made a mandate of law that every member contesting or voting should give a declaration that they would be contesting in one bar and voting in one bar only. that has been overlooked by the Honorable High Court of Nagpur bench. That is impugned order, my lords, placed at page number 1.
That's all right. What has happened now?
My lords.
Now, what is wrong with the order?
My lords.
Your concern is addressed in paragraph 3 and 4. Persons who have been, it is that bench gave a direction with regard to High Court Bar Association election that all participants and electors have to give an undertaking.
That's right.
That they are members of the Bar Association of the High Court and not of that Bar Association, they will not. And those who have given undertaking, their names have been directed to be deleted from the district bar electoral.
That's right, my lords. That's right. That's right.
What is the difficult?
That's not enough, my lords.
Not enough, then we are not sitting here to hold an election for you.
It's a reasonable.
My lords, all I'm saying is on 24th of April, the election is gonna happen. And there is no declaration called from the members of DBA Nagpur. And DBA Nagpur, the District Bar Association Nagpur, was a party to the writ petition which was disposed of on 16th of October 25, wherein it was a categorical direction from the Honorable High Court of Nagpur bench that declarations be called from all the members, and it was made a mandatory direction. But in the impugned order, it has been made a voluntary thing.
Sir, this is what we are trying to indicate to you, that that order has been complied with.
No, my lords.
So,
no.
The earlier High Court order, High Court Nagpur bench order 55, you annexed at 55, 56 of this SLP. There everyone was directed to give an affidavit, a declaration that they are voting for the High Court election.
That's right.
So those persons who given direction have been deleted from the district bar. That is the direction. So if you delete them from the district bar, so there cannot be a question of overlap.
This order is the next step.
My lord, it is complementary to the main event, that is declaration.
Please don't, Bar Association election, you want us to waste time like this. No case to interfere with the order.
My lord, this, I'll just take my lords to two paragraphs.
Thank you, you have already taken.
Lords, kindly have paid.
Matters you allow us to spend time on this.
My lords, just a minute, my lord, just a minute.
Thank you very much, thank you. Item 36.
My lord, then kindly give me liberty to approach the.
You have a full liberty.
My lords, all I'm saying is, if the election is not stayed, without taking declaration, the election will happen and it will violate the honorable court's order.
Orders have been taken care. High Court has not modified, not recalled the previous orders. Those are very much intact. Go seek their implementation.
My lords, all I'm saying is that if the declarations are not taken from the members of the Bar Association, that is respondent number 5 to the present list, the whole exercise which has happened in 2011 in this honorable court's judgment, that is BD Kaushik's judgment, which is the mandate of the law today.
Item 36, please. Pass over the known, pass over the date. Next.
Please. I withdraw this, my lords.
In item 37, my lord, we have filed the reply to the report of the amicus, my lord, and as well as the application for recalling of the order of lordships dated 10th of April 2024. That is IA number 114073 of 2026.
What?
My lord, we have filed, lordship had given us the permission to file the reply to the report of the amicus, my lord. We have filed that objections, my lord. And as well as that did not, we had made a mention that we had also moved an application bearing number 114703 of 2026 for recalling of the lordship's order dated 10th of April 2026, passed on the application of the amicus, my lord, seeking the certain clarification, which included the expansion of the scope of the, my lord, the order of this court and as well as the court of the, my lord, NCLAT, which is already, matter is seized before the NCLAT.
Financial creditors have given their suggestions to the learned amicus, not in terms of lordship's order of 30. We have placed our suggestions for consideration for amicus.
Malas, we are appearing for some of the home buyers. Lordship, we would like to continue with the present arrangement. Only the IRP may be changed.
Yes, please.
Rest, my lords, we are also part of the project-wise committees. So we also have a say in the day-to-day affairs. So Lordships would consider keeping, only the IRP may be changed, but the current arrangement of Project Wise Committee and the other committee can continue. That is our humble submission.
Equal participation by us also. There's equal participation by us also. We don't have an issue with that.
Preparing formula Union
May,
Bank of
may
India.
please your lordship. Lordship heard us last time. We read para 4 and 5 to say we are standing for a completed project. It's our project, fully completed, fully revenue generating. It's a hotel, it's a mall with a lot of shops. It's completely generating revenue. And my lord, we should not be put into the whole basket. Your lordship last time said, who and I?
You are presenting whom?
I'm presenting IFCI Bank, one of the financial creditors.
Whose instance this IRP was removed?
The board, the
Union Bank
the
of
insolvency board has.
Union of Financial Institution. Union Bank of Institution, which has a claim on.
Yeah, it's a financial institution. I'm a financial creditor. My lord, we are for this project. It's a totally completed project. It is earning revenues and they are not paying us because of this ARP process. So, my lord, we should not be put into the whole basket. Your lordship saw para 4 and 5. Various stages of incompleted projects, your lordship has said, group all together. In which, my lord, there is also, my lord, the completed projects also is now falling into this basket. Will your lordship sees para 4 and 5, my lord, the order. One last. We have moved our IA. Your lordship asked us to move our IA. Our IA is not one. Where is the order? Where is the order?
No, question is that how to segregate project, project wise.
Lordship said last.
We have to see the majority of the projects that where the home buyer's interest is involved.
But that's
Suppose
complete.
that.
I appear for Greater Noida. I appear for Greater Noida. Now, Mullah, there are four projects, Mullah, which are in residential and a sports city, which are part of Greater Noida, lands pertaining to Greater Noida. Now, Mullah has proposed a common authority. Now, Mullah, we being the land owning agency, Mullah, should be made a part of this common authority. Because ultimately it is our lands, Mullah. IRP also in earlier plans which were there, they didn't consider what is to be paid to us.
Same is in my case, lordships, where I represent, let's say, the home buyers. We can request at least not the completed project.
My lords may take the 10th April order, my lord, of your lordships. 10th April order.
Para 4 you are reading.
And para 5 also, my lord. At this juncture, we hasten to note that there are approximately 30 projects undertaken by the company in question, out of which 16 have been entrusted to NBCC for completion by way of judgment dated so and so. In our considered opinion, the issues relating to remaining projects also ought to be administered within the same court-monitored framework. Accordingly, the underlying policy with respect to all the projects, whether fully completed, substantially or partially completed, or which are lying incomplete and inactive, including those which have been handed over to NBCC, shall be determined by a common authority that may be set up in this court. But we have no difficulty in, at least I'm not. But
it was only to ensure a smooth and uniform administration of all the projects.
Yes.
There is nothing like that intention is that somebody will snatch from a project and hand over to.
Only slicing, well, all of us here.
Our difficulties, our resources is going to be used by the IRP now in the common pool of a completed projects. Our resources are going to be used in the other projects.
These 16
are
projects
self-sustained.
should be kept separately.
16 should be kept separately as regards the completed ones. We have a grievance against that, your lordships.
And NBCC has been doing a good job, my lords.
But this issue,
Substantial progress.
Being a government of India
Yes,
corporate
my lords.
entity might be doing reasonably well. We have no reason to doubt that.
Right,
We are
my
not
lord.
saying anything.
this issue of 16 versus 30 is actually pending before NCLAT.
NBCC is now, as of now, is a kind of a project proponent.
Yes.
That they are executing the project.
Yes.
We are talking of a committee who can overall monitor the whatever the generation of funds, then the utilization of those funds, the liability, the financial institution, Now Greater Noida is also before us. Ultimately, there will have to be some determination of these claims.
May I suggest that, apropos to what the court observed, rather than getting into detailed submissions, of course, we are ready. Your Lordships, this may be an issue as well, which is considered by the NCLAT along with the assistance of the amicus, rather than do it here. Because here, Your Lordship, because this appeal was disposed of. The amicus was to address the NCLAT on that issue with regarding the RP, etc. You know, I think there's a consensus that if somebody has been suspended and the organization can't move forward, then of course there must be a substitution. Yeah, so so that's just to facilitate. That's a small thing. But to alter the scope of the appeal, Manoj, we have some reservations. It's much better to do it before NCLAT, where we get a full day in court.
For NCLAT.
Sorry?
It came on Friday, Milaz.
It came
Yes.
last Friday.
Said that you
next
must
Friday.
come to your lordships for any change. Today, same project Mr. Venkatraman was talking about. We are shop owners. There are no home buyers. In this. Now our problem is all those people like Pizza Hut, etc. Whom we have used as the shops. They are saying now we want to cancel those because now you are being pulled into this.
Putting it in great jeopardy, Manoj. This last order of 10th April.
I agree.
It came last Friday. It's
Lordships, the issue right now is that the non-16 projects part of that company, the corporate debtor, is being handled only by the IRP. There's no one else who looks after it. And the liabilities of the company are 9,000 crores, over 9,000 crores. There are cross holdings, there are mortgages, there are guarantees. There are all kinds of relationship, inter-project, within the company, with subsidiaries, with associate companies. Someone needs to look at all that. Till the time, their worry perhaps is that the CIRP process of the entire company, STL, your Lordship's order should willy-nilly not endorse that, because their appeal is pending on the subject of CIRP of the non-16 part of the company.
That's correct.
Now, as far as the completion part is concerned, sir, yes, many of the projects have been completed 15 years earlier, but requisite regulatory approvals are not there. Completion certificates are not there. The authorities.
There can be,
Sir, I'm not speaking for any specific one. I'm giving an overall picture.
That's the problem.
Mr. Jain is not referring to any individual.
Manoj, may I say this, Manoj? That
There are
10th
issues
April
related,
order.
all of them.
Mr. Jain, there must be some valid concerns, but as the court of first instance, let the NCLAT take the court.
Yes.
Mr. Jain,
Sir.
Can we at the first instance request the NCLAT?
Yes.
Yes, Lord. Yes, sir. Yes, sir.
Yes.
I think so.
What is the date in NCLAT?
Next Friday.
24th.
Our matters are coming next Friday.
All right.
Coming Friday,
Manoj, but Manoj, your Lordship's observations in 10th April may be suspended.
But till that time, sir,
If our order which we are proposing is okay, it's only a proposed order we are dictating.
sir, till that time,
Say with reference to the tentative opinion expressed by this court in the order dated 10th April 2026. It is pointed out at the outset by learned senior counsels.
With regard to the amalgamation of all projects.
In our order dated 10th April 2026 with regard to amalgamation of all the projects for the purpose of constituting one supervisory committee.
Apex Court Committee was the terminology. Apex Court Committee was the terminology used by the NCLAT.
To bring under the control of the one, under the one court committee, court constituted committee. It is pointed out at the outset by learned senior counsel, counsel representing various parties, home buyers, financial institutions, Greater Noida.
Commercial.
NBCC also.
Commercial.
Yeah, financial, it's there.
Etc.
That would embrace everything.
That this issue can be effectively gone into by the NCLAT, where the matter is now coming for hearing on 24th April 2026.
I don't submit to the Greater Noida may not be there. All the
Just a minute.
Exactly.
The learned amicus, Mr. Rajiv Jain learned amicus is also the view that the learned NCLAT may examine this aspect, especially in light of the fact that the IRP has been suspended on account of some the
Violation of some
as a
contract.
result of finding some alleged misconduct. Full stop. In this view of the matter, we request learned NCLAT to consider the issue as to whether or not a code constituted committee should be appointed for the purpose of managing the affairs of for amalgating and managing the affairs of all the projects of Supertech, and or such arrangement should allow the continue only in respect of the 16 projects which have been entrusted to the
NBCC.
Right?
Yes.
One application.
And they may decide uninfluenced.
Wherein I am willing to pump in 1,500 crores.
No, these arguments you have to raise there.
Because
Can't examine the.
Your lordship may say that uninfluenced NCLAT will decide uninfluenced.
But all these 16 projects, we may move the NCLAT. my lord.
Since we have not expressed any opinion on merits in this regard, liberty is granted to the parties to raise their respective contentions before the learned NCLAT. Also, we also allow the Greater Noida to seek its impediment and represent its claim before the NCLAT.
Well, the first concession may not be recorded on behalf of Greater Noida. My concession that I have also agreed that yet NCLAT is the proper authority, my lord, to look into, my lord, that may not be recorded in my.
Court order. That's a court order.
That's not a concession.
There's no concession.
No, we are not.
But that
Uninfluenced, uninfluenced by the finding in paragraph 5 of the Lord.
If I may, sir. In respect of the 16 projects also, currently the IRP is suspended. And for the rest of the 16 projects, IRP is suspended. And he was the only one looking after them. So who should look after the rest, the non-16 part of the company, till the time the NCLAT decides on the matter? That is one, sir. Second is that IRP is the chairman of the Apex Court Committee, which looks after the 16 projects. He's suspended. So the 16 projects, their work is also in a limbo.
Exactly.
So
we need to be considered before NCLAT.
Next Friday it will be considered, my lord.
In the earlier order, there were two links. One was the prompt and immediate replacement of the IRP.
Yes.
And the second was to explore the possibility of collating all these projects under a common management committee.
Yes, sir.
So that, as you indicated, there is some interoperability, interliability, which can be thrashed out. So since there is a sort of divergence of views that this may not be in the interest of completed projects or the other non-16 projects, then we are remitting that to the NCLAT. We have categorically indicated in our today's order that the replacement of the IRP is one of paramount.
Yes,
importance.
correct.
That's right.
That's right.
Once that is addressed, at least the 16
Projects will
be
continue.
taken care of. The non-16 projects, whether they, as per your report, there is some interdependence on each other, that NCLAT will examine.
Definitely.
And maybe hive out some, maybe which are more dependent, keep them as adjutants to the 16 project. That's up to the NCLAT.
Great.
Your lordship, 10th April order, my lord, they are not able to take any.
Usual observation, not
Uninfluenced by the.
My lordships, there are project committees as well, which is being created by the Apex Committee in NCLAT through some order. These project committees are the representatives of all the home buyers of all the 16 projects. So even they need to be considered with anyone, let it be amicus or let it be IRP.
My lords, our application for, my lords, in response to an expression of interest, my lords, we have given our expression of interest, willing to, for these 16 projects, my lords, 1,500 crores. That is not being considered.
We are rejected all those.
Let me go back, my lord, because there is an order.
We are interested in
10th April, only point is 10th April order clearly says they can't take any major decision. That is why, my lord, they are not able to take application.
Lordship was making a request regarding uninfluenced by the para 5, my lord, in the order dated. Lordship was in the midst of that, my lord.
No, we have said only tentative.
Tentative, my lord.
Grateful, my lord.
Uninfluenced. My lord, uninfluenced.
Just go on and on.
Tentative is very heavy, my lord. My lord, it would may affect.
Authorities, as the lordship knows, have huge demand. And one of the submissions made by the learned amicus is that the 70% which was to be given out shared with the landowning authorities and banks, etc. That need not happen, my lord. That is something on record of your lordship. So it should not happen that, my lord, whatever was considered by the enclave stands amended because the amicus is saying so, my lord, with all due respect to him.
No.
So therefore,
I beg your pardon. Your lordship's order of 5th February, your lordship's order of 5th February.
that's it. Secondly, not the apex board, apex committee does not have contained any land owning authority as a member. They are, Noida.
We have not prosecuted any apex committee today. That's why we are requesting.
Yes, that's right.
Yes, the one.
If I may add another thing.
Our admitted claims are there, my lord, which was.
Uninfluenced, my lord.
Your lordship's order of 10th April.
Since the ongoing 16 projects entrusted to NBCC are also facing stalemate after the suspension of IRP. It goes without saying that the matter involves urgency. We therefore request NCLAT to hear the matter, subject to other prioritized matter on the date fixed, that is 24th April 2026, when counsel for the party have also assured to extend full cooperation to INCLAT for the purpose of hearing. Post this matter for further consideration on so date.
Not uninfluenced.
Grateful, my lord.
Uninfluenced by the lordship.
Don't please.
Your lordship's order of 10th April, my lord.
Very heavy, my lord, on the NCLAT, my lord. Lordship's approach of, lordship's view of, my lord, tentative.
Your lordship's order of 10th April, my lord, restricts any major decision being taken. That, my lords, your lordship may para 7 of 10th April order may be modified accordingly. Because, my lords, ultimately, my lords, even the applications which we are filing, they are saying that probably they won't be able to take a call because of the 10th April order.
All right, item 45.
10th April order, my lords, kindly clarify because.
Lordships in item 33, lordships in item 33 of Supertech Limited, in which you had asked the amicus to conduct a survey of the home.
We are issuing notice and asking.
So no order had been dictated. I just thought I'll flag it to you.
33 issue notice, then the complete set of paperwork we handed over to learned amicus, who shall verify the counterclaim of the Residents Welfare Association on one hand and the pieces on the other. Then so and so accept notice on behalf of the Resident Welfare Association. The counter can be filed within 2 weeks. Post this matter on same day.
Not very lordship said Greater Noida will be made party, we should be also made party because after our claims, this got disposed of because sent to NBC.
You are Noida.
The Yamuna Authority.
Yamuna Express.
They also need to be made a party because they've cancelled the allotment despite the court's direction. Despite the court's direction that the liabilities of the authorities would be met subsequent to completion of project. So I would request the bench to direct the YEDA.
All the land owning authorities like Greater Noida, Yamuna Express, so and so authority may also be implemented and heard by the land owning.
Very obliged. Very good.
Well, our application then will file before the NCLAT. My lords, the lordship may only say, my lord, nothing.
People know very well.
Ultimately, my lords, because of the 10th April order, we
are not sending before a school child. There is a tribunal headed by a former judge of the Supreme Court.
Lordship may say all parties can move the NCLAT.
Thank you very much. Thank you. Item 58.
Yes. Please, your lordship, this is a bail application. This is adjourned. So before my.
पूर्व बंदित्वाचा असल
Mr. Nataraj, what is the, how long the trial will
I think
continue?
I am, because there was no special court as such. Now, because now the special courts are likely to be set up, I think we'll be able to conclude the trial. Now, 39 have already been examined out of around 64. If possible, we will try to prune it further.
any new other charges different or the same charge?
No, they are independent. They are independent. That's independent.
Sorry, the witness has entered the box in Odisha and said these are connected matters. The witnesses are identical and the charges are exactly the same, travel.
No, how can the allegation is identical, madam? The allegation is identical in the sense that allegations are that you are involved in terrorist activities. You have been found guilty in Delhi. Their occurrence must be something different.
No, they're not. That is the point I'm making. But that whether it's double jeopardy or not, the trial court will see. But even if my lords will see the table which I handed over, even the witnesses are the same. And the 39 witnesses who have entered the box have exonerated, and 20 of them they've declared hostile. And twice the High Court has said complete the trial by the December 2023. They have failed to do it. Completed by December 2024. They failed to do it. Between December
Some
14.
institutional difficulties, the courts were not there.
We also, that incidentally, that matter is also listed today, where we have through judicial intervention now constituted special courts which will
10 years.
Actually,
allow the things to happen in uncertain.
around 25 are pending. We can further prune it once, because day after tomorrow is the date, right? 29th is the next date.
Take a firm view within which time you will be.
I'll give you this one. I'll give you.
This is not something that it will take years.
It will not. We can finish it maximum within 6 months. We can try to finish the entire trial.
10 years he has
Yeah,
been
we can.
my lord, on the same allegations. And here it's not just merely a broad terrorism. You traveled to Saudi Arabia in on 5/2/2015 is the exact allegation in Delhi. He has been convicted. He has served out a sentence of 7.5 years. The second thing is that some 1,50,000 came in to your trust account. The trustees have entered and said the trust is properly managed. They have not shown that it has been wrongly applied. And all the witnesses who have entered the stand have not, only thing is about speeches. 25 of them have declared them hostile because they say there is nothing in those speeches. The others who come and
That
see.
unfortunately, in your case, that presumption of innocence pending trial is not very much there. You have been found guilty, you have been convicted.
But the,
You are found to be very well actively associated with one of the dreaded organizations everybody knows on the earth.
how many times can I be tried and sentenced on the same count? My lord, even
You
assuming,
have some rights. Society has also right to live peacefully.
but 10 years I've been in custody, my lord.
Yes, because of your sentence.
No. My sentence is only 7.5 years. I've completed it. My lord may take it. I am today only an under trial because my 7.5 years sentence has been completed by me. I continue in Orissa.
This trial is now going on where?
In Orissa.
No, which place?
Cuttack.
Qatar.
Exactly the same charges. My lords will look at it. Exactly the same material, not just charges. So your lordships, even assuming double jeopardy does not come in, Section 427, your lordships have held, if it's the same transaction, the sentences will have to be concurrent. So in any case, even assuming I'm convicted and sentenced, it cannot go beyond those 7.5 years I spent.
No doubt about it that whatever you have, maximum sentence only you are liable to undergo. You can't be kept beyond that. There is no doubt about it.
I'm saying if Delhi on the same allegations, I got 7.5 years. It have to be concurrent because it's the same transaction. I've already spent 10 years.
All right, just a minute. Today that incidentally there.
That matters.
Is,
Odisha Advocate General is here.
Mr.
Acharya.
Yes. Mr. Advocate General. Now, all of you know, we can see now some of the familiar faces sitting here. Some of the Advocate Generals are here. You know, we have requested all of you for a special reason.
Right.
Now, most of the states have these scattered trials under UAPA, by NIA. And there are some other, like the other special statutes.
NDPS also, I have come with the proposal today, Milord.
The central government has, in principle, not only in principle, they have sanctioned now. They are providing, I think, once the matter is taken up,
2 crores.
2 crore or 3 crore, they are providing for, no, they are 2 crore, they are providing for infrastructure. No, it is slightly more than that. We will find out. Now, in any case, they will provide you the recurring expenditure also for running these courts. So what is required to be done is that meanwhile, the high courts, of course, because we require the state's cooperation also, and the high court also will have to do it. You will they will spare one officer who will exclusively deal with these trials on day-to-day basis. Our mandate is that every trial must come to an end within 1 year of the arrest, so that this kind of challenges we are not required to face. Now, the state will have to extend cooperation in the sense that initially that infrastructure, creation of establishment of construction of court, recruitment of one officer, these might take some time. So we will deal with when the other matter is taken up. Meanwhile, this matter is of Odisha in Cuttack. Who will be dealing with the state is prosecuting or the
State is the prosecuting agency.
So the state is prosecuting.
State is prosecuting.
State is prosecuting.
So you will ensure that your public prosecutor, that your one dedicated prosecutor remains in court. You will also ensure that all the remaining witnesses are produced before the court. And we are fixing a timeline of 2 months to complete.
That can be done. That can be done. I'll ensure it.
When will be the courts closed? Any idea, Mr. Advocate General?
High Court, Odisha.
District courts in Odisha.
On 15th of May, I think. No, 31st May. This year they have extended 31st of May.
31st of May.
31st of May.
Or 31st of May they will close.
My lord.
And during even vacations also, the criminal trials continue.
That can.
In any case, in this matter, we will direct. The trial will continue. We will fix day-to-day basis and
We'll engage a special prosecutor for this particular case.
Right down.
My lord, we'll just keep the matter pending and keep a date in July.
Grant.
Because otherwise I'll have to start again from the trial court and take another. Your lordships have done it in other.
No. Trial court, we will exempt, we will grant you liberty. We will mention in the order everything. We will pass a composite order. So the petitioner was one of the accused in FIR number 67/2015, dated 14th December 2015, registered at Police Station Special Cell, Delhi, under Section 18(18)(b) and 20 of UAPA, Pura Naam Likhna Act. The allegations were that he was indulging in teaching anti-national ideals and was actively involved in aiding the recruitment of youth to Al-Qaeda in Indian subcontinent. In the above stated FIR, he was arrested on 15th December 2015. The trial was conducted and the additional sessions from Patiala House Courts, New Delhi, While judgment dated 10th February 2023 convicted the petitioner under section 18 and 18 capital B of UAPA. He was sentenced to undergo RI for 7 years
7 years and.
7 years.
7.5 years,
with fine of rupees 25,000.
which he has completed. He's completed the sentence, my lord.
Next paragraph. The petitioner has undergone that sentence. Next paragraph. However, there is another FIR number 244 stroke 2015 dated 17th December 2015
Well, 3 days after the.
registered at police station Jagatpur, comma, what is UPD Cuttack?
UPD Urban Police Department.
Comma, Urban Police Department Cuttack under section 17, 18, 18 capital B and 20 UAPA. The petitioner, since the petitioner has been arrested in that case also, and the trial is still pending, comma, he approached the trial court. He firstly approached the trial court and then the High Court for his release on bail in the above mentioned Odisha case. The High Court, while impugned order dated 11/11/2025, has declined him the bail, comma, giving rise to these proceedings. Next paragraph. The petitioner's primary contention is that he is in custody for more than 10 years. And since he has already completed his sentence in the Delhi FIR, comma, he deserves to be released on bail. Next paragraph. Shri K. M. Nataraj, Additional Solicitor of India, representing NIA and Advocate General representing the state of Odisha. You are for NIA or for state of
Odisha.
Or say, Mr. K. M. Nataraj, Additional Solicitor of India, as well as Advocate General, appearing for the state of Odisha, have opposed the prayer. It is just that having regard to the nature of allegations and the material on the court, comma, it may not be, it is not expedient, it may not be expedient to release the petitioner on bail. Next paragraph. We have considered the rival submissions at this stage, comma, instead of going into the merits of the petitioner's prayer for bail, comma, we deem it appropriate to dispose of this petition with the following directions. One, can we have the name of the nomenclature of the court where trial is pending?
It is Spatak.
This is petition.
Trial court order. Trial court order.
Evidence.
FT case number is all in place. Trial court order. Sessions Judge Cuttack.
Sessions Judge Cuttack.
ST case number 103 of 2017.
Session
Court Cuttack, ST case 103.
Court at Cuttack, before whom ST case number 103 of 2017 is pending trial, comma, is directed to take up the above stated trial at least twice in a week. Why? The prosecution is directed to ensure that sufficient witnesses remain present for examination on all the dates. 3I, the Honorable Chief Justice of the Odisha High Court and the portfolio judge of Cuttack Session Division are requested to temporarily transfer other urgent matters pending before the above stated presiding officer and entrust the same to other courts.
Mr. Sessions. Thank you very much.
Yes. The learned session judge before whom the trial is the example is Honorable Chief Justice and the portfolio judge are requested to facilitate the learned session judge.
Precedence over all other matters.
Session judge in such will
will
allow the learned session judge and allow the learned session judge to entrust other matters pending in his court to the courts of additional session judges, etc., or to urgent or to urgent such matters which are not urgent in nature. To urgent the matters which are not urgent in nature. Next paragraph. The learned session judge, namely the presiding officer of the trial, will not list any other case on the date when the trial in the present case is to be taken up. On that day shall be entirely spent in recording the prosecution evidence so that all the 25 prosecution witnesses, remaining 25 witnesses can be examined as early as possible. Next paragraph. Subject to the defense evidence that may be led by the petitioner as a matter of right, will direct the learned session judge to ensure that the trial is concluded within a period of 2 months. Next paragraph. Learned Advocate General has pointed out that the summer vacations in the state of Odisha for district courts shall commence with effect from 1st June 2026. Also, keeping in view the particular facts and circumstances of this case, it is directed that the trial court shall continue to function till the trial is concluded. And if need be, the presiding officer will be entitled to avail vacations at the later part of
Liberty maybe.
Later on. Next paragraph. The defense counsel, the public prosecutor, as well as the defense counsel are directed to remain present in court throughout the day and assist the presiding officer. In this regard, no adjournment shall be sought or granted. Here, next paragraph. No witness shall apply and be exempted from appearance except in a case where such witness can be examined online. Next paragraph. Subject to, however, how is the trial is, the moment we will say, they will take these.
My lord, after 10 years, I think he's entitled to attempt for his liberty. So my lords will either keep this pending or give me liberty to come straight here, because otherwise it will take another 2 years.
Our only problem is that the moment we will say that in case of some unforeseen circumstance it does not happen.
My lords, we can show whether the circumstances could have been foreseen or not. If there were such circumstances, they can always plead it. But some liberty may be given to me because twice they have flouted
It
orders
goes
to
without
complete.
saying that if the circumstances will so warrant, the petitioner shall be entitled to approach the High Court
Directly, my lord?
Milord, may I pray, Milord, can it be 3 months? Because this summer vacation,
My lord?
hardly a month is left. It is so therefore, during the holidays, I do not know, there's 3 months. Months.
From today then.
And that would be, Milord, may I suggest that is not 3 months, but 1 month is intervening vacation.
I think 3 months.
So unless the courts,
2 months,
4 months, 4 months, because that would be, because 34.
Thereafter, the presiding officer may give an opportunity to the petitioners to leave the defense evidence if any,
And Milord,
and conclude the final hearing. Final hearing within 2 weeks. In 2 weeks. Or within 1 month. Within 1 month.
Now that they have
That
3
is
months,
total 3.
if they don't complete within 3 months, then my.
Then we have said that however,
Unforeseen circumstances,
However,
lords may not qualify.
35 witnesses.
however, if on account of unforeseen circumstances, the trial is not concluded, the petitioner is permitted to approach the High Court directly.
Not 10 years.
The rest is in 2015 and it's the same transaction.
Leave it.
So it's more than 10 years. Even Orissa, it'll be 10 years in June.
Please, great.
I'm okay.
Lord, in this matter, I'm the special public prosecutor for the coal, my lord.
CBI.
Coal matters, my lord, can only be filed with an advance copy to, my lord, the SPP and the advocate on record. It has not been served. My lord may post it to 2 weeks. Let them give me a copy. That's the Supreme Court's directive, my lord. I don't know how registry passed it.
No, the order under challenge is only for regarding that.
No, that's all right. But I don't have the paper book. I have nothing. I saw that in the, I'll assist your lordship on.
Issued so far.
Advance copy as per your lordship's directions are now being served. So we serve the same.
No, my lord, my friend, I'm not clear. I'm not clear. In coal matters, a copy is not supplied to the special public prosecutor. That is the Supreme Court's order. Coal bench's order.
Difficulty in
So
supplying.
I'm only saying, give me a copy, have it next.
No difficulty as such.
So that's all I'm.
We should not attach the property in between. This company is in liquidation. So the point is whether a company which is in liquidation.
How are you affected if the
No, I am in the liquidator, Millards. I am the liquidator. The banks, Punjab National Banks and all started CIRP proceedings. I am appearing for the liquidator.
My lord, I have the answers to all the legal questions. My lord, the company is convicted. It is fined on 2 counts. First, my lord, in the trial court, they said 32A. The resolution failed, the corporate insolvency resolution. That was not available. Now they are saying the liquidator wants to sell the assets at a higher price. Therefore, again, my lord, 33(5) doesn't come to the rescue. But since it's a legal issue, I would like to assist your lordship.
To best of our knowledge.
That's the only thing. And they ought to have served me a copy.
Can I address what has happened here? Just have a look at 32A. 32A2. Lordships will have 32A2
Of IBC.
IBC code. Can I just indicate the facts? This company had loans of 5,000 crores. I represent the OL, not the management, Millards. This company had loans of 5,000 crores.
Well, once the company goes into liquidation, there is no scope for 32A.
32A2 clearly talks about,
I thought that, I didn't notice that you are representing company through liquidator.
yes, the company is through liquidator.
Yeah, but the question is that 32A probably doesn't apply. And if that is not so, then fine has to be.
So just
recover.
because today what happens, there are these assets of the company.
Right.
I am only to serve for the banks who have given.
You are to satisfy the claims as per the priority.
Correct, Milord.
Correct.
Right, Milord.
So this fine
Yes,
is recovered under the law
Yes.
as land revenue.
right, Milord.
Correct.
Right, assume that to be so bad.
If it is to be recovered as a land revenue,
Yes.
are you going to argue as an official liquidator that the company in liquidation will be absolved of its liability to pay land revenue?
No, Milord, I'm only saying that as per 32A2, it deals with both, Milord. Just have 38A2, Milord. Just have a look at 38A2. 38A1 doesn't deal with liquidation, it deals with a plan. Just have a look.
Read out to.
No action shall be taken against the property of corporate debtor in relation to an offense committed prior to commencement of the corporate insolvency resolution process of the corporate debtor, where such property is covered under a resolution plan approved by the adjudicating authority under section 31, which results in change of control of corporate debtor to a person or sale of liquidation assets under the provisions of chapter 3 of part 2 of this code to a person who was not, that is not related to etc. etc. Now today in the facts of this case, there is one
person, the sale cannot be made to a person
yes
who is subject to the
disqualification.
disqualification.
So-
That is the restriction on sale.
Yes, Vilas.
And the earlier part of the clause relates to a corporate debtor in existence.
Yes.
The minute the liquidation order is passed, that is
Yes.
the company is wound up.
Yes, Vilas.
The proceedings don't end
Yes.
only with regard to defray of the assets.
Correct, Vilas.
It is like the juristic, juristic person has expired.
Yes, Vilas.
The juristic person no longer exists.
Correct.
Now the official liquidator is appointed
Yes, Vilas.
like a receiver over the assets
Right.
for administration of the assets.
Correct, Vilas.
Correct?
Correct.
It's like if it's a natural person, is the executor of the will.
Will, correct.
So in this situation, can the official liquidator argue that the assets of the liquidated company
Yes.
would not be subjected to a land revenue claim, would not be subjected to a claim of tax,
So, Vilas, today,
any claim arising from the
Today,
state's
below-
sovereign powers?
two parts, please just bear with me. I was liquidated in 2019. The person came in, I came in 2020, because RP came in 2019. No plan came. In 2020, liquidation order is passed. The trial proceeds against the company. I go and tell the company court as a liquidator, the criminal court as a liquidator, saying this relates to the previous transaction.
Doesn't matter.
And secondly, that even a
Does not matter until and unless a resolution plan is accepted by the committee of creditors.
Sorry?
And that resolution plan creates a de novo management
Right,
of the affairs.
Correct.
32 capital A does not trigger it.
Milos, just have a look at 32A once again. Milos, there are two
Yes.
provisions, 32A1.
It is with us.
Huh? Sorry, Lordships, have a question.
So despite confusing language and non-stop sentences,
Milos, so what will happen, Milos? Just give me a minute. There is this asset of the company, which is land. I have to satisfy to sell the land.
Sir, anyone who will buy the land will be subject to the fine payable to the state.
That's what is not is that is what is sought to be got over by 32A by a notwithstanding provision, Milos. It will defeat IBC provisions, Milos, if your lordship say that the fine of 1 crore will attach to the property. Then nobody will buy the property, Milos. That's a difficulty today. Then a liquidator will not be able to sell the property. So on one hand, you have Punjab National Bank who wants the property.
no, you sell the property and pay deposit this amount.
No, that's why, Milos, that's why whether that property is liable to that fine amount, Milos, in view of
Exactly.
32A.
You are not It's not a case that you are asking for a time to dispose of the assets and pay the fine.
No, my lords,
You are saying you are not liable.
yes, my lords, the company's assets which has gone into CIRP liquidation, otherwise these words or sale of liquidation asset will become redundant under 32(8)(2), my lords. Just have a look at 38(8)(2)(2). 38(a)(1) does not use the word liquidation, my lords. Just have the difference in the language. Just have a look at 32(a)(1) and 32(a)(2). 32(a)(1) says, notwithstanding anything contained to the contrary contained in this court or any law for the time being in force, the liability of a corporate debtor for an offence committed prior to the commencement of CIRP shall cease. So the liability will cease when, and the corporate debtor shall not be prosecuted for such an offence from the date of resolution plan has been approved by the adjudicating authority, ... So just to explain how I understand it, suppose the company is being prosecuted for 420 offence, which was being prosecuted here. One plan comes, some new person comes and bids and takes over. The prosecution itself will stop. The company cannot be prosecuted at all. So suppose this company, some plan had come and it had got sanctioned in 2019, the company wouldn't have been prosecuted at all for this offence, Millers, which was committed prior to the CIRP process. So no question of fine, etc. would have come. But unfortunately, no plan came forward. So the NCLT ordered liquidation. Once the NCLT ordered liquidation, then 38(8)(2) uses the word liquidation specifically, which is not there in 32(a)(1). No action shall be taken against the property. So Lordship will see, no action shall be taken against the property of the corporate debtor.
This line, sir, or sale of.
Or sale, yes, my lords.
Liquidated asset. Asset which is sold.
So, and secondly, my Lordship said, so sorry, so sorry, so sorry. I'm
Lord, I only want.
Yes, you get the copy and reply to the last portion or
My lord.
mail.
That's all I said.
Yes, yes.
Issue notice can say. Who is assisting? Are you assisting in that?
Who is assisting?
Accept notice on behalf of the suspended.
No, this part.
Mr. Arasimha, learned public prosecutor for CBI, senior deputy and special prosecutor, public prosecutor for CBI. Seeks and granted. How much time just to file a court?
2 weeks.
Whatever time suits.
Post the matter on so this. Just advise them not to auction the.
Yes.
tools.
They're not to attach, Millers. They have put for attachment tomorrow, Millers.
Attachment is nothing attached.
The attachment will continue. I can't do anything in that. We'll see that.
Attachment is there only.
Whatever it is, status quo, there's no difficulty.
My lord, I'll issue the other instruction. My lord, we'll not say anything that way.
Right, sir.
My lord.
May it please, my lord. My lord, unfortunately here, my lord, what has happened is, in my writ petition, my lord, a sitting MLA calls up, my lords, the honorable judge, and the honorable judge expresses his distress. Your lordships will find at page 22.
So that's why contempt has been.
No, my lords, now what happens, my lord, just have a.
Writ petition has not been heard.
Yes, my lord, I have not been heard. I have said, in fact, in my writ petition, four representations I make. My lord, the Honorable High Court should have taken it on the administrative side. Finally, I am constrained to.
No, he was
My writ petition is disposed of. I have several reliefs, my lord, which I have claimed. I want to be heard, my lords.
It has not been disposed of.
It has been disposed of. The
Earlier writ petition.
that is still pending, my lord.
So you pursue that.
My lords, my respectful submission is, lords, kindly see, my lords, my reliefs in the present writ petition, which has been disposed of.
Yes,
Your lordships will have a look at, my lord, page 80.
Can't do anything
No,
before
sir,
this.
that
Sorry, my lords.
come to the reliefs.
Yes, my lord, page
Please
80, my lord.
Show the reliefs.
Page 80, my lord.
Page 80.
Yes, my lord. So kindly have a look
There
at.
was one relief
Yes, my lord.
which relates to the predicate events, that is the illegal mining.
My lord,
by-
that writ petition is pending.
So
I am saying, my
your
lord, the
concern-
action of
Your
calling up.
concern, Mr. Kamal, your
Yes.
concern is that there should be an impartial investigation with regard to the illegal activities of respondent 7.
That is one aspect, my lord.
That is the only aspect.
No, my lords,
where
kindly
you
see,
need
my
to
lord.
cover.
Prayer regarding removal him from assembly. How can it be allowed by the High Court like this?
I'm sorry,
Unless
I've not
for
been
the
able to make
contempt, the High Court hold him guilty. We understand that. Suppose somebody is held guilty of, in terms of the allegation against him, then probably you are entitled to, anybody else can also be
Lord,
entitled.
just have a look at just two things, lordships may bear with me. Please first have a look at page 22, my lords. This is the order which is passed in my writ petition. Mr. So and so, I don't want to sensationalize, my lord, kindly have a look at this.
Yeah.
And this pertains to, my lord, 1,000 crores, my lord, illegal mining. The state is refusing to, my lords, take the dues. So and so has made an attempt to call.
Stand
No,
your.
no, this is contemptuous. This is plain contempt.
So
my lord.
there's so much to contempt.
Now, my lords, just bear with me, my lords. My lords, High Court, my lord, in all fairness, should have taken so moto cognizance of this. This is blatant contempt, my lord.
It has.
No, my lords. No, my lords.
Saying no.
Just have a look at, just bear with me, my lords, for 30 seconds. My lord, I filed representations from November 25, my lords, to January 26. With the Honorable Chief Justice, no action is taken. Finally, my lords, I am constrained to file a writ petition. My writ petition, my lords, is at page 63. And at page 80, my reliefs are there. Apart from taking, my lord, cognizance of contempt, I have asked for, my lord's investigation into this
You
whole
may ask for
matter.
any-
Because today, my lords, what
That
is happening?
Most
Lord-
of the time, these political battles are also
Lord-
fought inside
Lord,
the
is
court.
this a political battle, my lord? Calling up a judge? I'm sorry, my lord, with the greatest of respect.
The moment he is held guilty now in contempt proceeding,
Yes, my lord.
all other consequences will follow.
My lord, that is not going to happen for the simple reason that last occasion, my lord, the senior counsel appeared saying that he just, my lord, ऐसे अचानक से लग गया, and they're going to, my lord, file an affidavit of apology, and that is going to be accepted. Now, what I want, my lord, is that let me be heard. It was on my writ petition that cognizance was taken. Now, kindly see the impugned order, my lord. The impugned order says that I have no role to play.
This is again a political statement. That will not happen like this, sir. Who are you to dictate the court?
I am not dictating the court.
What you are doing?
Lord, I am just saying this is what happened in the court.
What's going to happen? He has filed this
My lord,
affidavit.
he is saying
You are
that I
taking
am
the
going to
court
file an
order.
apology.
You have become a new
Lord,
fashion.
Lord, with great respect, my lord, with
We
greatest of
don't
respect.
appreciate and we
My lord,
replicate this kind
My
of
lord,
practice.
with greatest of respect, my lord, I am only seeking that I.
Understand how you must be misbehaving with the judge there.
Yes, my lord. That's all I am saying, my lord. My lord, what I am saying is he calls the honorable judge.
Therefore,
and no
his
action is
has been
taken.
taken.
Lord, on whose request, my lord, I ask myself.
Very good. You have
Yes, my
brought
lord.
it to the
So
notice.
I have also other reliefs. Please have a look at the reliefs, my lord. Please have a look at the reliefs.
Criminal contempt proceeding.
Yes, my
Where have you sought your hearing?
Lord,
How's
kindly-
the application?
Lord, kindly have a look at my prayers, my lord. Please have a look at my prayers.
That was in the writ petition in which the criminal contempt proceedings have been initiated.
Correct, my lord.
When criminal contempt are initiated,
Yes.
these are separate proceedings registered.
Correct, my lord. Correct.
In those separate proceedings,
Yes, my lord.
have you sought that I may be also be heard?
My lord, apart from the criminal contempt, my lord,
seek that?
I will seek that, my lord. But apart from the criminal contempt, I have sought for other relief. There has to be
Other
some.
reliefs are absolutely premature.
Please
at
have a
this
look
stage.
at this, my lord.
Other reliefs are on the presumption that someone is guilty of a misconduct.
My lord,
First, concentrate on proving that misconduct.
my lord, would your lordships then kindly give me that liberty, my lord? Because High Court is of the view that once I have filed the writ petition has been disposed of. My lord, kindly have a look at page 3, my lord. Petition is disposed of, and now it is treated as so
You have
moto.
not argued anything
is-
else.
My lord,
We can very conveniently say you do not argue anything.
no, I'm not saying that, my lord. Please have a look at page 3, my lord, of the impugned order. My lord, the High Court treats this as a suo motu contempt. It was, my lord, a contempt initiated on my writ petition. I am only requesting the court that I will be of some assistance to the Honorable High Court. I have a lot of material, my lords. Otherwise, what, in my respectful submission, the apprehension is,
If you have material, you should supply to the High Court, you should place it on record before the High Court in
Lord,
all
I will,
fairness.
that is what I'm asking, my lord. That is all I'm asking. Please, my lord, allow me to be heard.
Learned judge has so much strength to tell in the judicial side of the order that somebody dare to.
Yes, my lord. Yes, correct. my lord.
There you don't appreciate. When the High Court initiate criminal contempt, you don't appreciate. I wanted him to, because you have some political mileage you wanted to achieve, those have not been dealt with by the High Court rightly, and therefore you start accusing left
Lords,
and right.
I am only submitting that, my lord, let me be permitted to place my case before the High Court, my lord.
Who has stopped you?
My lord, the High Court kindly see the
Why
impugned order.
do you want to go via Supreme Court? Why can't you go directly?
My lords, kindly see my writ petition has been disposed of, my lord.
Disposed of writ petition? No. Disposed of by initiating criminal contempt proceeding.
Lord, I leave it to your lordships, my lord. I want to be heard. Lord, lordships I will withdraw this with liberty to go to the High Court, my lord.
First of all,
Yes.
in the criminal contempt petition
Yes, my lord.
or in contempt proceeding.
I have no right to be heard, my lord.
Between the court and the
Correct,
contempt.
lordships are absolutely right. That's why I
Even
submitted.
then we can understand. You could still say to the High Court
Yes, ma'am.
that please allow me to assist you
Yes.
because contempt proceedings have been initiated at my instance. If the High Court suppose doesn't hear you,
Yes,
you can still come to us. Look here, here's a matter where I should assist the court.
yes. But I am only requesting that much, my lord. My other prayers without any adjudication, my lord, have been disposed of. Either your lordships permit me to, my lords, intervene in the contempt,
Mr. Dev,
my lords.
Kamath, who knows better than every day you file political matters and you don't know these.
Lord, lordships may not make such comment against us, my lord, kindly with respect.
Not against you.
Not, sorry, my lord.
You have a better knowledge than others.
My lord, I am not such a, my lord, I only file political matters. Please don't say that, my lord.
Political
Now, kindly,
in the sense that
sorry.
you know the implications
Lord,
of this.
what is political in this, my lord? My lord, a person, my lord, calls the honorable judge and says, my lord, I want to have a discussion with you. We file a,
And must not be, if somebody is guilty of committing this kind of conduct, today we cannot comment because the matter is pending.
yes, my lord, I am only requesting that let me be heard. my lord. Yes,
This kind of misconduct.
yes, my lord.
He must be taken to the task.
That's all I'm asking.
No doubt about
Let me assist the court is all what I'll withdraw this with liberty to go back to the Honorable High Court if your lordships are not inclined to.
Senior counsel for the,
Yes.
after arguing the case for some time, then senior counsel for the petitioner seeks him permission to withdraw this petition as he wants to assist the
Yes.
High Court
Yes.
in the suo motu criminal contempt proceedings that have been initiated through para 6 of the subject order dated 2nd April 2026. This is the right approach only.
Yes, ma'am. Grateful, my lord. My lord, with that, with the aforesaid liberty, my lord. Lordships, sir, that
Liberty.
SL
We have granted you liberty, but
the lordships only recorded my submission, my lord. Disposed of with that liberty, my lord, kindly.
liberty for what?
For going back, my lord. Lordships have said, my lord,
We have said that you want to assist the High Court. We have
Yes.
said so.
disposed of with that liberty, my lord.
You have deliberately chosen the word, Mr.
Yes, my lord. Yes.
that you want to assist the High Court
Very
in
well.
the suo motu criminal contempt proceeding initiated wide para 6 of Orders 1.
Very well. We'll take that. Grateful, my lord.
May it please this honorable court, my lords. My lords, in February, I filed a writ challenging the concerned rule. My lords, in February, I challenged the concerned rule. My lords observed that it needs to be changed. On 11th of March, Bar Council of India has changed it. Implementing it on 18th March, high powered.
Why are they not doing? Are you there for the Bar Council?
I'm for the Bar Council of India, Lordship. Item 57 listed today is a similar matter, Lordship. Senior Counsel Guru Krishna Kumar sir is appearing for that. So it will be requested to take it.
Similar. Where is Madam Radhika normally appears for Bar Council of India?
Yeah, I mean, I'm with Dr.
State
Ramshankar.
Bar Council or?
Yeah, I'm standing counsel's office from
For which?
Dr. Ramshankar. Ramshankar's office, Your Lordship.
Are you appearing for Bar Council of India or State Bar Council?
No, Bar Council of India.
Then call who is appearing there. Why are not passed the order in terms of the earlier directive?
Lordship, that would be answered by Mr. Guru Krishna Kumar in item 57. Actually, we have no idea about today's convention.
Page 58.
62 to be heard with.
Lords find that they have amended the rule, but they are not implementing it. 58, my lords would kindly.
Lordship, we have amended the rule and it's been placed for your Lordship's consent in M. Maradan matter. We have filed an IA for the same. We have amended the rule.
Call immediately. Who is appearing?
Amendments have taken place at a point of time when many of these states have already completed the election process.
Now, my lord,
In respect of Maharashtra, we passed the order not to
understand.
interfere.
I understand.
Because the nomination papers were already
Now in
circulated.
Maharashtra, my lords have
Other
said,
states also.
Maharashtra, my
Can
lords
we
have
really
said
have
that we
different
are,
standards for different states?
my lords, in Maharashtra, my lords have said that we do find them to have a case to contest, but since it's too late, ballot papers have already been published and circulated, we can't give them indulgence, my lord. So my lords have never been of the opinion that it can't be given.
We are definitely not. But what we are really concerned is that in Maharashtra, because the election process had gone to a much more matured stage, we could not give the benefit. Now, the same standard should apply to the election process across India. It's a Bar Council of India election. Look at it's almost salt to wound that the Maharashtra candidates could not participate, whereas the Madhya Pradesh candidates
And
could
my
not.
case is slightly different, my lords, because on 18th March, Madhya Pradesh High Powered Committee allowed us. Madhya Pradesh High Powered Committee implemented these rules, and we have given undertaking in the our nomination paper that we will resign. Now, I had no occasion, because committee has allowed it, High Powered Committee, we have given undertaking. Now, Justice Dhulia's committee observes that this is wrong on the part of Bar Council of India. Justice Dhulia has decided it, but then he says that we are helpless because we can't proceed with it. Now, my difficulty is that in Madhya Pradesh, High Powered Committee has already allowed it. Now, once having allowed me filing my nomination paper as per the rules,
Why is he not complying with the earlier direction?
Lords, they have, I understand they have already amended. What has happened is this, that amendment has been, resolution has been passed. Then it has been circulated, my lords, in M. Varadan, that matter with regard to election, where the Bar Council is seeking the approval of this honorable court for the rule to be given effect to. That has been placed before my lords. Just have a look at this, my lord. My lords, there's a resolution. Just have a look at this. It's been filed, my lords, in March itself. This has been filed when? 12th of March in M. Varadan.
IA for the purpose of that rule to be approved by us.
Why you are seeking our approval?
Just have a look at that, my lord. That's how it's been.
Passed any conditional order earlier that you require.
That's true. That's true. I quite see that.
That's precisely the reason as to why my application got rejected.
Just have a look at page 8.
Guru Krishna Kumar, this is not a rule which emanates, which comes from the Bar Council of India. This was a rule amendment pursuant to our direction.
Correct.
So there is no question of approving that.
I understand that. I did discuss with them.
The order of 19 to 2026.
That's correct. That's correct.
We suggested that please make this amendment.
Absolutely.
Within a week's
Now
time.
you come before us with an IA that we have made this resolution, please approve.
No, I did
And
discuss
that was
with
to be
them.
done within a week's time, my lord.
It has
So
been
19th
done
of February, it's their abject failure, my lord, which has.
My nomination got rejected primarily because of that.
The problem is we will be creating
Item
an
57.
estimate fee.
My lords,
Exactly.
I'll answer that, my
The
lords.
schedule
I'll answer
has
that.
been
Allow
gone
me,
through in the
my
meeting.
lords, allow me, just give me indulgence. I am appearing in item 66 for 5 office bearers, my lord.
Just one.
My lords, some dates are crucial. It's not irreversible in Madhya Pradesh.
Just one.
Allowing to have this monopoly kind of thing, that bar association also you grab, bar council
My
also.
lords, I'll answer that. My lords, I'll just note few dates, my lords. I'll satisfy.
They can indulge in all kind of.
My lords, that's not there, my lords.
undertaking is there. In Madhya
My lords,
Pradesh,
my lords,
situation is slightly different, my lords.
My friends, my lords, can hold on for a minute.
Has implemented these rules.
The election date is 22nd of April.
My lord.
Nomination papers definitely have been published by.
My lords,
No,
that's
my
time.
lord. In
My
fact,
lords,
final list of candidates is to come up on 22nd of April. Voting is on 12th of May, my lord.
my lords, some dates, that's what
Time for withdrawal of nomination papers.
My lords, some dates I'll point out on fingertips that in Madhya Pradesh.
Even in Madhya Pradesh, my lords, process
Lord,
is ongoing.
Let's,
Honorable Justice Bakshi Square, my lords had asked me, just a minute, my lords have asked me that whether we
I
can
want to
adopt
take
the
up
same yardstick for Madhya Pradesh. My lords, it's not irreversible in Madhya Pradesh. Just give,
What's
it's
that?
not, I'll just give some dates on fingertips.
Seeing two persons
Yes, ma'am.
in a same election process in a pan-India being governed by different.
With due respect, that's what I'm saying. It's not same. Allow me, my lords, to point out few dates.
I think if my friends can hold on for a couple of minutes.
Absolutely.
My lords, I'll satisfy it. It stands on a different footing.
My friend would hold on for a minute.
11th, my lords, may please note some dates. It's not irreversible in Madhya Pradesh. 11th, just a minute. 11th April, my lords.
Madhya Pradesh, we agree with Madhya Pradesh is not there. But what about the states where elections are
Earlier,
on
my
in
lords declined.
February?
Yes, my lords, I am answering that. Earlier, my lords declined in case of Maharashtra because my lords have observed that we are with the petitioner, but because ballot papers are printed, it has become irreversible. Therefore, it is being declined. Here, my lords, may please note. Here, my lords, the nomination were accepted. Here, my lords, nomination were accepted. They were rejected.
You are asking us to pass an order which per se will be a discriminatory action on the part of the court.
My lords, with due respect, it will not be because my lords, we just see the election program. I am item 66, my lords. 22nd, they have to come out with the final list. Please see the election program. It's unlike Maharashtra, where my lords observe that process and much of water has flowed, which is irreversible.
We understand that.
Yes.
We understand that. But can you deny the fact that it is the same election?
My lords,
Election.
no, it's not the same. It's, my lords, it's different.
For the purpose of administrative management, that in two states the election is held in February, January, two states in February, other states in March, now in April.
Lords, there,
All
lords,
because meanwhile the amendment has been.
lords, there, with due respect, if the candidate approached this court late, why should we suffer? Here, my lords, we have been on the toes before this court, my lords, since February 1. And then, my lords, what I am requesting, just see the election program at page 67.
My lords have seen page 8 and 9, my lords of the SIA.
I am not
Page 8 and 9 of the SIA, my lords.
Last order in February, my lord.
Amendment is page 9.
Correct, my lords, page 9, at the foot of that page, my lords. Commencement and applicability. This amendment shall come into force from the date of its publication in the Gazette after due approval from the Honorable Apex Court. This shall apply to all cases where elections have not yet been held. Therefore, it is because of this has been passed, my lords, and placed before my lords. And it is on this basis that the supervisory committee also says.
If Mr. Guru.
There's one aspect also further I wanted to highlight. This is one part. Second is the supervisory committee on that basis says in most of, I'm in 57, my lords, where the election is being held today. So what is falling from my lords? The elections where they have already started and they are going on should really be on the basis of the equal
They are at different pace.
stages, but it's a single scheme, my lords, at the end of the day. It's a single scheme. One aspect though, there's an incongruity I must point out. In fact, I discussed with them also. Just see the last part, where elections have not yet been held. It does say.
That is why, if you had said in your amendment where election process has begun, we would have agreed with you.
I would say.
You as the rule-making body, say election has not been held.
I think you would bear me out for a minute.
With due respect, my lords, allow me to say so. They have actually they are in contempt of this court. They were required to amend the rule. They have not amended the rule, my lords, within a week.
Lords,
Lords,
I think they should hold on for a minute, Lord. We are trying to sort out.
I'm
saying
with
this,
due
my lord.
respect, there was no need to seek approval, my lord. They were required to, the order is categorical of 19 February that amend the rule within a week. My lords, they did not do that, my lords. Why should now the hammer fall on us, my lords, is my respect.
This rule is itself a notification, my lords. It says the notification in exercise of powers such and such, this notification is being issued.
And very interesting to note, in West Bengal, actually, they allow it, in fact. Yeah. My lordships may have the direction passed in West Bengal, your lordships.
Well, my case is slightly different. My nomination was rejected on the basis of
बस एक लाइन बोल।
एक मिनट। Yes, please, sir.
हम क्यों कोर्ट आते हैं?
My lords. 10th, my lords, nominations open. 10th nomination open, my lord, page 67 of my item 66.
We have nominated your submission.
My lords, one more, last line, my lords, before.
Rejected.
My lords, 8th, my lords, why Madhya Pradesh stands on a different footing? One more reason. 8th, my lords, nominations opened. Here, unlike other states, my lords, our nominations were accepted. All that 11 candidates, nominations accepted.
Already argued that.
Yes, my lords. And then, my lords, there was no reason for us to approach this court. And then, my lords, they rejected.
You should thank Mr. Guru Krishna Kumar's.
With my lord permission, my lord, may I say?
Yes.
I am appearing for the lady member.
I'm in a very unenviable position, my lords. I told them change it. The nitty-gritty of what they are doing is really in their hands.
One word.
Some office bearers of the Bar Associations challenging Chapter Roman Capital 3 of the Bar Council of India, uniform rules and mandatory guidelines for the elections of Bar Councils 2016. Under that chapter, the office bearers of the Bar Association, the elected office bearers of the Bar Association were debarred from contesting election of the state bar councils of the state bar council, though they could contest such election after resigning from the post of the bar association. The said petition was disposed of by this court on 19th February 2026. Was disposed of wide order dated 19th February 2026. Paragraph 3 whereof reads as follows. Next paragraph. In purported compliance thereto, Bar Council of India has amended Chapter 3 via notification circulated on 11th March 2026. But such amendment has been conditioned to come into force only inverted commas after due approval from, don't put in comma, after due approval of this court. The amended chapter 3 has been placed on record by the Bar Council along with along with IU number 78285 of 2026, filed in writ petition serial number 1319 of 2023. Next paragraph. Chapter 3, as amended by Bar Council of India on 11th March 2026, reads as follows. Here, page 9 below. Next paragraph. It seems to us that the grievances of the elected office bearers of the bar associations has been adequately redressed through the amended provision. So the same is accordingly approved. The same is accordingly approved. Now nothing more. That they are already colliding with you. This is.
And 5 PM, the list has to come out.
After 2 days,
So
my
we
lords.
have time. If my lords would kindly permit, let our nomination paper be scrutinized as per these rules.
The amended provisions may accordingly be published in the official gazette of India without any delay. Next paragraph. As regard to the enforceability of the amended chapter 3, approved above, a decision will have to be taken on case-to-case basis.
That's okay.
We accordingly dispose of the reasons listed today and also permit any other agreed party to approach the high-powered election supervisory committee headed by Mr. Sudhanshu Dulia, a former judge of this court, in this regard. The court shall be at liberty to take an appropriate decision or lay down guideline in relation thereto.
My lords, may I request my lords to kindly observe that Justice Dhulia's committee may observe as per these rules, may
We
decide
have
as per
already
these.
said, we have talked about these rules only.
One more request. Plus 22nd, 5 PM is the last date. The Dhulia, we'll approach them today itself. They may take a decision by tomorrow.
You can go today itself.
There is one more request. There is a writ petition we filed on Saturday, not on board, my lords. Identically situated petitioner, not on board, my lords.
We filed on all other matters also. We have already said so. We have
This number may be mentioned. One more thing. This number may be mentioned. I'll give the diary number.
Applying the notice.
Thank you very much. Thank
Nomination
you.
was
Now please
rejected
go.
on the pendency of
Look,
the.
just one procedural aspect.
All matters to pending है वो भी ले लो.
One procedural aspect. I'm in 57.
My lords, the order may we trouble.
I'm in
the-
57.
May we trouble your
62 and
lordship.
66 also relate to the same subject.
Lords, may we trouble your lordship, the order may be given today, my lords.
The court then will make correction.
Lords, there may be.
Unreasonable innovative demands from you.
My lords,
Now, next item 63.
Very well.
Lords, 66 is with 62.
My petition is already handed over, so my lord, my petition also discussed.
Thank you very much, sir.
I have passed on with the diary number, my lord, identically situated petitioner. They are also.
Thank you very much. Thank you. Thank you. Item 63.
Lordship, I am for the petitioner in this matter. The quashing petition filed before the Delhi High Court has been pending since 2014, and it is only fixed for the final arguments, and it has been pending since 2014 for the final arguments, my lordship. So, my lordship,
Now listed for final argument. What is the next date?
my next date is 25th, my lordship, on the early hearing application again.
Very good. Then early hearing.
But they are not, my lordship, back in the year 2025 also we filed the early hearing application, which was dismissed as the court deems fit that there are more other cases that they had to look upon it. So it was dismissed. But my lordship, for filing the present writ petition, my urgency is that the accused is the sole surviving accused is in petition. And my lordship also, he's a senior citizen and having medical ailments. He has done, like, he has been through orthopedic surgery and he has done like hip replacement. So my lordship, he is not able to work. He is having like physical distress as well as financial. So
What are the
like,
facts giving rise to this petition?
my lordship, actually, we were the export companies who were taking the credit facilities from the bank, which is the respondent number 3. And with regard to it, just because we constrained, like financial distress was caused in this case, so our account was like declared NPA by respondent number 3. So respondent number 3 has even like filed recovery proceedings before the DRT. And the DRT, and while the matter was pending before the DRT, the settlement has already been done. We have paid the amount, whatever was the like the financial loss was caused to the bank, we have already paid it. And we are even having the no objection to the said petition. I mean, said case, my lordship.
Well prepared.
Applies, my lordship.
Keep it up. देखो भाई बच्चे को दे दो relief. The petitioner has filed criminal miscellaneous number 3926/2014, seeking quashing of second criminal proceeding. It is stated that the petitioner is the only surviving accused, and he too is suffering with various ailments. The question is sought on the basis of a purported settlement with the bank, with the Punjab National Bank, in terms whereof the agreed amount already paid to the bank in the year 2007. Next paragraph. Without expressing any opinion on respect to the allegations or the claim made by the petitioner, our having regard to health issues highlighted before us, we request the High Court to expedite final hearing in criminal MC number 3926 of 2004. Yes, sir.
Much obliged, lordship.
Thank you. Next, 64.
My lords, I am appearing for a cooperative bank in item 64. My difficulty is that there's a judgment against a former employee which has come against me. It is pending before the Honorable High Court in a review that I have filed. Now that bench comprised the then Honorable Chief Justice and a senior puisne judge. The Honorable Chief Justice, the then Chief Justice, has since superannuated. And there's no special bench comprising this combination. On 5 occasions, we have mentioned this before the Honorable High Court. There's a new Honorable Chief Justice. He said he'll put this matter before a new constituted bench. Unfortunately, there's a registrar sitting in Dehradun who is somehow determined to reinstate this lady. This is a long drawn 11-year litigation. I'll just take my lords through the facts of the case. There's a lady who's worked in my bank since 2014 to 2015 for a 7-month period. In 2015, she resigns. In 16, I accept her resignation. She's lost in High Court twice. And my lord, there's a contempt. And indulgence from here, my lords, only to the limited extent that till my review and stay is pending.
You have mentioned judgment of the High Court. We dispose of this special petition at this stage. Is a request to Honorable Chief Justice.
And my lords, the order may not be given effect because the registrar proceedings are pending on Monday.
Uttarakhand High Court. So, ascertain the facts. To list review application number 10 of 2025. Preferably before his own bench. And the earliest. Special Christian dispute.
My lords, the order may not be effective.
Sorry, sir, we will not grant any.
Grateful, my lords. This is the individual petitioner for her own case. I was there in the 2002 list. I have a passport. I voted ever since. My prayer is very limited. My lords, my prayer is very limited. I appreciate, my lord. My lord is not on the larger question. My lords will examine that. My lordship is examining. In the 13th, my lords, April order, my lords had given liberty to the writ petitioner there to seek out of turn hearing because my list closes on 27th. I am seeking the same liberty. That's all. Page 69, my lords, para 40.
Approached or you are yet to approach?
Sorry, my lord.
Have you already approached?
Yes, I filed on 3rd of April, but unfortunately I haven't got a hearing. I just want that liberty and I'll move the lords forum. That's all.
The petitioner has already approached. He applied for the on 3rd April 2026. Being aggrieved against or exclusion. It will be SIR process. Exclusion from the voter list. SIR process. Reading relevant paragraphs. We request the appellate tribunal to approve out of turn hearing. Appeal. Appeal at the earliest. At the appeal. Out of turn, we are, sir.
Yes, sir. Grateful. Grateful.
This is a case where I am a developer. Lord, I have developed 180 flats and given possession in 2020. There is no case against me, Lord. Lord,
that can be investigated by the CBI.
Sorry, Lord.
So that can be investigated by the CBI.
So what happens is, just bear with me, Lord. So 180, Lord, I gave possession in Lord 2020. I was not in the High Court. I'm not in the Supreme Court. One gentleman who wants a refund went to NCDRC. I have deposited 2 crores, my lord. He wants more. I want to be less. All that is here. That is a case of refund. He doesn't want a flat. There is no home buyer standing, knocking at the door that this man has run away. So, my lord, taking advantage of this fact that the lordship's matters are here, he files an SLP, my lord, after 2.5 years, saying that his case is the same, so that an FIR is registered and he can twist my arm, my lord, in NCDRC. I want to show you, my lord.
Mr. Ogri, we do not.
These are the flats.
First of all, we are not aware that how many home buyers were there, how many are satisfied with the.
Not one is dissatisfied, my lord, not one in terms of flats.
There may be a representative voice before us.
Nobody is there. I gave it in 2020, we had in 26. Somebody would have come. This is the nature of flats that I have built.
This is a matter of investigation. It's only because we have issued common directions. Today, if we interfere, everybody will come back to us that I am ready to compromise, I am ready to settle, I have done this.
So we are not taking advantage of the fact that matters are pending. An SLP is filed 2 years after my lord we leave to appeal. He is neither in the High Court nor I was in the.
No, that SLPs are coming very late, not in one matter, in hundreds of matters.
Correct.
In hundreds of matters, we have entertained.
But in each one, there are home buyers standing on the Supreme Court door saying that this builder has run away and he has not given us flats. There is not a single person because I gave it in 2000.
Therefore, it's not something that they have seized your property or any coercive order has been passed. Why don't you put up all these facts before? They have, in most of
now ED will start against me. CBI has registered without a copy-paste FIR that there are builders. It's a copy-paste FIR. Have a look at the FIR.
Registered again only pursuant to what direction?
But below the direction is not meant to be abused by a person below who's not there, who is wanting his money back. He's not below a flat, knocking for flats. I've got all 180 flats below here in Gurgaon, given to everybody. People are living there. 175 people are living there. Somebody would have said something. Somebody would have come to the Lord. 6 years they've been living there.
No. If number one, we are not sure that how many home buyers on this side or on this side.
Ask the Amicus, ask anybody, Milord. Don't accept my word. But this can't be that one person will take advantage.
Then in this kind of matter.
I can satisfy him, Lord, that this is the position.
Cursory reading of the relevant papers of both the parties, sir. The allottee made initial payment of about 10 lakh rupees in 2014 for a flat to be delivered in 2017. And that he took a loan from the HDFC of about 1.2 crores, of which he paid about 10 lakhs right at the outset. About 32 lakhs was paid by the HDFC in 2014 to the builder. And then ultimately, the flat was not delivered in 2017. It was in 2018, a payment of about 62 lakhs is made by the HDFC to the developer, part of the home loan, as part of the home loan. Ultimately, the
62 lakh, 32 plus 10.
Yes, sir.
More than
10 from the home buyer, 32 from HDFC, 60 lakhs something from the bank to the developer. Also, sir, in between, the petition of the home buyer states that the developer had assured that he would service the EMI till the time the flat is delivered. But then the developer reneged on it. So there was some exchange of emails, and the last email on the subject was of 2016, when the developer assured that he will continue to service the EMIs. And that the developer has serviced, he has paid some amounts towards servicing of the pre-EMI, so to say, the interest, not the principal component. So bottom line, sir, is that a substantial amount, 60 lakh paid by HDFC in 2018 to the developer. I'm not sure at what stage of construction that was. The developer maintains that the disbursements by the bank to the developer were in conformity with the stage of construction. I do not have the stage of construction list to show at what stage in 2018 was the stage of construction that the bank gave over 60 lakhs to the developer. And so as far as components of subvention are concerned, your lordships, the developer assured to service the EMI. He has partly serviced. Initially he reneged, then subsequently exchanged of emails, then serviced, again reneged. Then second component of subvention, that whether the disbursement by the bank to the developer is in conformity with the relevant stage of construction. I'm unable to ascertain that. In this matter, so the CBI has registered an FIR. Presumably they would have custody of all the relevant records and they could look into that.
I have given flats to everybody in 2020. And this man in 22 has gone to NCDRC.
The point is that, Mr. Rotri, if the other home buyers silently have accepted, and if there are gross irregularities or illegalities in this recovery of EMIs or the financial institution involved in it, then how we exempt them?
Lord, with great respect, Lord. If 175 people have taken possession and are living there from 2020, today in 26, one man wants a refund. Refund issue is going on. I've deposited the money under the decree. This can't be not a case of twisting somebody's arm.
Let's inquire into it. They can submit a report to us today. I mean, this matter is still pending.
I can not satisfy my friend. What are the EMIs? What is the construction? I can take him to the site.
Representing CBI in that case, you can, whatever you want to submit, you submit to the.
I will, but Lord, tomorrow ED will start up. I have no case against me. This is one man, Lord, trying to misuse the court's process and saying, now, Lord, lodge FIR after FIR. See the FIR. It's a copy paste of 500 FIRs, which is not the position. In my case, have a look at the FIR. Just have a look.
FIR may be copy paste because for them also it is very difficult.
Those are cases where, Lord, people are knocking the door of the court for possession. And the building is not come up. This is not that case at all. Lord, have a look. I am showing you, Lord, people are living there. This is not something which can't be verified, Lord. People are living there, Lord. These are the flats.
If I may, your lordship, the main issue in the subvention-related batch of petitions is not so much the non-delivery. Of course, it springs from non-delivery of the units, but main issue is alleged collusion between banks and builders.
And the builders. That's why on case-to-case basis, somebody, even if maybe some element of innocence or at best a case of irregularity, but still that nexus part has to be.
There's another point which the buyer states.
Years ago.
Buyer states
Not
that
somebody
the
brought to the-
occupation certificate which the developer is showing is for a 4 BHK flat. Sorry, 3 BHK, while the allotee had been promised a 4 BHK. And there was a builder buyer agreement for this.
4 BHK is not an issue. I mean, if he wants money, we are disputing, Lord, I have deposited 2 crores, he wants 2.5 crores, I want less. That is going on in NCDRC. How does it become, Lord, a subvention case in the Supreme Court after 10 years? Can you file a report? Lord, I have no problem, Lord. Let my friend check, look at the property, look at how people are living, and tell your Lordship, Lord, am I one of those who should be, Lord, put in the same branch?
If the people are living there, if they at one point of time, they have been coerced, like, leaving no remedy for them or options for them, and by virtue of that entire process, if the financial institutions are found to be hand in glove, that part will have to be investigated by Mr.
That would arise if, Lord, the
Then
builder took the money.
Let other home buyers be also there.
Let him give your Lordship a report. Lord, please hang me if your Lordship finds that, Lord, I have run away with somebody's money.
Then it will become
no other
affairs for us.
But then I am not in that boat, my lord. Because of, my lord, a blanket order, some people, my lord, take it.
We will find out and will submit a report.
Ask for a report, my lord, no problem. I am here.
No,
But it can't be, my lord, misused in this fashion. My lord, why did that man file an SLP after 3 years? Why? Your lordship may see that.
Mostly SLPs are filed after 3 years, 4 years. After the High Court, Delhi High Court.
Right. But, my lord, this is a case where he's in NCDRC for last 3 years.
For refund.
NCDRC, my lord, was moved in 2022.
For refund.
No,
Your lordship may see, my lord, NCRDC has ordered.
Whatever you want to submit, how many total apartments were there?
Total for 180, my lord. 180 apartments. I have got photographs of all to show you, my lord, people are living there. And this man doesn't want a flat, my lord. He wants money. This was an investment scheme for him. So we are quibbling about money, whether he should get 2 crores or 150 or half or whatever. And I have deposited 2 crores. Have a look, my lord, at the order.
State Commission order, page 260.
See, my lord, the State Commission, the appellate order of NCDRC.
Running company, so many projects.
I am a running company, my lord. I am debt free. I have no such problem. I will now be caught, my lord, in this issue which is pending in the court, my lord, where a person is not concerned. I can understand, my lord, if I have done.
Only ask the CBI to look into all this.
Let them give a lordship a report, my lord. I have no problem. Let them give a report, your lords.
No, we will not ask for any report. That will become, because we will assume the role of trial court then.
But we are submitting reports from time to time, my lords. Submit it there.
Lord, I can explain to CBI. I can
that you can.
But, Lord, Lord, ED should not start on that. Lord, I will be roped in by then ED by all this. Lord, my name will become mud.
Is a developer of the project. That is still at 70A, success in Gurugram. And petition number 2 is the director of first petition.
Sorry, Lord, can I just take one more minute before Lordships complete the order? A part of a Lordship's order, when SIT is constituted, the order is, it will be necessary to constitute an SIT to uncover the nexus between the banks and the builders with respect to development of projects where the home buyers have paid substantial amounts and where development projects have not even been launched or completed or not begun construction. This was the scope, my lord, not a scope for 6 years, my lord, I have completed the project and my lord gone on with it.
We are not saying that you might be.
This is the lord, this is the scope, my lord, to catch, my lord, delinquent builders. I am not a delinquent builder, my lord.
None of this applies to me.
I am not in the clutch of this, the parameters of a lordship's order.
Since CBI has registered. FIR. Administration Economic Development in 1 New Delhi. Against the prisoners in perpetual compliance of our order dated 23rd September 2025 and subsequent orders passing a batch of retributions, batch of SLPs, stock retribution, seeking thorough probe to realize division and connections between real estate builders, developers, builders, and the financial institutions. The above affair has been registered at the instance of respondent 1, at the instance of respondent 2 and 3, who are also the home buyers of, who are also the home buyers in the above stated project to be petitioner. It is averred that out of 180 units that the petitioners had 180 units in the above stated project, and barring respondent 2 and 3, no other home buyer has any complaint against them.
Correct.
Since the CBI is already investigating, so we have heard one single counsel for the petitioner, as well as Mr. Rajiv Jain, Ranga Micros, and Madam Appeal and additional solicitors who are presenting the CBI. As per since the CBI is already investigating all the issues comprehensively, dispose of this petition with liberty to the petitioners to produce the entire material before the CBI to enable it to look into the allegations made by respondent 2 and 3, as also the claim as projected by the petitioners. That as in they will require the
We should not take any coercive steps without the leave of the court. I will be sunk. I have got no case against me, nothing in that.
The next paragraph. As rightly pointed out by Aswariya Bhatti, the CBI is already filing status report from time to time in the lead case. It goes without saying that in that process, the claim as asserted by the petitioner before us may also be verified.
Yes.
Please, ma'am.
Yes. Definitely.
Malaz, would it be your lordship's pleasure to take item 49 now? Learned AG's, Malaz.
Yes, 49, in fact, taking 48.
All the learned AGs are here.
So Malaz, both issues, NIA, I will assist your lordships, and UAP and NDPS, my colleague. So we filed a status report, Malaz, if your lordships have. And Malaz, the Monday hearing was very useful, Malaz. We made good use of it yesterday also, Malaz.
Nice evening.
Now, there is some confusion with regard to the total amount which you are giving as one time.
Your lordships have noted it in the last order, Malaz. It's 1 crore recurring and 1 crore non-recurring. So 1 crore non-recurring will be a one-time.
Non-recurring is also 1 crore.
Yes, Malaz, because we expect the state to provide the land and building, Malaz.
Now, you see, the issue is very small. But at the same time, it has very serious ramifications on the ongoing trials. And particularly in those cases where you have seen one of the Metro Odisha, that people are there in jail for the last 10 years, 7 years, 10 years, 5 years, whatever may be. And this creating a lot of problems for different channels before the special court, then high courts, and before us, and the Metro bail. And very well predicament. On one hand, the allegations are very serious, so the courts are also reluctant. But on the other hand, there are question of liberty, Article 21, all these issues do arise before us. So the only way out was that we create some dedicated courts exclusively to deal with these matters. What has been happening is that state government will write to the High Court Chief Justice that you need a special court under SC/ST Act. So suddenly a notification will come, so and so court is notified as SC/ST Act. Next day you need a court under NIA Act. So then another notification, that very court NIA Act. Third, then under NDPS Act. This is how, and then family matters, all civil matters, criminal trials will continue before those courts. And that special court becomes a mockery. That is what practically all of you know very well, better than us. So it's only to wriggle out of this kind of difficulties which are being experienced for ensuring a timeline for conclusion of trial, that we requested the central government to come forward and provide some assistance to you. And with the, we have no words for appreciation for Madam Aswiya and Mr. Sanjay, that both of them really were able to convince the central government that now this they have finally agreed to. Now this 1 crore rupees per court is that if you, this will all depend upon that how many cases are pending in a state. So this will be a dedicated amount exclusively meant for, say, construction of, you require 10 crore, they will pay you 10 crore non-refundable. If you need only 2 crore, they will pay you 2 crore. Am I right?
No, my lords, it is 1 crore non-recurring, my lords. Because we expect land and building to the state to provide for that, my lords. But, and recurring will be 1 crore, my lords, each court. So your lordships already saw, it is not
each court.
Each court. So if the states are establishing more, then my lords.
So the question is that now you need to, wherever these cases are pending, we have requested you to be here only for the purpose of that you immediately need to provide us space for these courts. If the space is already there, well and good. But as we said that these courts are having now multifarious responsibilities. We are talking of the courts, say under the, for example, NYAYA court or NDPS court. These courts are right now occupied with other matters also. The question is that how to ensure that they are able to take up only exclusive cases of NIA or say NDPS. On day-to-day basis, the trials will have to be conducted. All of you will recollect that old timers, the practice used to be that once the session trial would commence, it will continue on day-to-day basis unless it is concluded. That pattern, of course, because of the overburdened courts, that practice has been really given up. So, but for the purpose of these matters, we need to reintroduce it. So you will have to help us that you talk to your concerned high courts. One, this court has to be in the adjoining building, in the same building, or the nearest complex, which must be acceptable to the bar people also. Because otherwise it will create problem. If it is 1 kilometer away, the bar members will have a lot of difficulties to experience. So ideally, it should be in the same complex, at the same place. And it should be only one court. So two things will be your responsibility. One, to immediately give one courtroom and the requisite infrastructure. Second will be, for that High Court will also be, and that will be our next phase, the additional post to be created. Say, in your state, if you require 10 courts, in another state you require 5, in the third you require 7. So to that extent, there will be a temporary addition for the time being in your higher judicial service cadre. It will not be ex-cadre, it will be part of the total cadre strength, because here we need to have very trained and experienced judicial officers to conduct these trials. You can't give a raw hand, today selected and then appointed. So they will have to be very, having a good, fairly experience of conducting trial with them. So this will be an addition in the cadre for which recruitment, normally higher judicial service recruitment is done by the high courts. So that, as we say in the second phase, we'll take up that issue. For the timing, you need to provide the basic infrastructure for which you will get, say, renovation, repair, creation of the court facade inside the building. All these they will provide you 1 crore rupees. And for running the expenditure, that 1 crore per annual budget will also be provided to you. And you must have seen in the sanction order, the total assisting staff, that is also depicted in the central government order, so that there is no confusion about the logistic support that the presiding officer will require. So this is what probably, and we really appreciate that with one node, all of you will agree and you do the needful.
But in Jharkhand, we have one exclusive court not within the same court campus. Exclusive court for NIA. From 2024, it is functioning, Lords.
Very good.
So, and
It's
is it exclusively dealing with
exclusively, Lords, it is notified by the central government under Section 11 of the NIA Act, and from Lords 2024.
we have only one court is sufficient in that?
Lord, we have only 27 NIA cases.
NIA.
As of now, Lord, it is, I think, Lords.
You can have one more.
We can think of that notes, we can't.
Why we are saying,
Yes.
suppose you were two, you finish the trials, and then judicial officer can be given other work.
27 is included of state prosecution also.
UAP,
Not, we have notes, separate note, there are two provisions notes.
There are two provisions. The state can also prosecute under UAP.
Yes, yes, note, we have done that, Jharkhand.
The central government.
That's right.
That is, central government does it through NIA.
That's right.
So whether 27 is the entire number of UAPA cases
No, no.
or it's only NIA cases?
No, only,
National
only those NIA cases, note, only those UAPA cases, note, which NIA has taken up.
NIA. And how many UAPA cases?
Note, around more 3,000 plus cases.
State has 3,000.
No, I'm not, NDPS 3,000 and
We are talking of UAPA.
UAP 790 cases.
790 cases.
Yes.
So how many people are in jail in those cases?
Notes, we have designated all the principal district judges of all the districts notes under section 22 of the NIA Act for dealing with UAPA cases.
See, that is what exactly our apprehension was.
Yes.
Because that is what problem is creating. You, I mean, you are also in a difficult situation, we understand. Those 790 matters, we will see, rarely any person will be on bail.
Note, we have 24 courts for them.
No, but those are not exclusive courts.
What are
They are not exclusive.
What are the number of under trials in your 790 cases? So our main concern, sir, is not the central government or the state government. The impact of these legislations where the right to under trial bail is limited because of statutory interdicts.
That data note will have
We
to
need
collect
to
notes.
have a situation where there is a fast pacing of these courts. If you have a central government NIA court and you have 13 or 27 cases,
27 cases exclusively for NIA.
very healthy situation.
What we will request
But
all
about
of you-
700 odd words,
UAP.
cases with about, let's say, trial of around 700 to 1,000 people.
And
If
this
you are
may not
having
be-
a slow paced
this may not
trial,
be-
it completely defeat the purpose.
It may not be a situation in
Use
another
this
state.
money if possible to set up those UAPA cases for state prosecutions also.
But we are doing that notes. We have designated every principal district judge in every district under section 22 of the NIA Act for UAPA.
Wonderful. Why, how many cases non-NIA or non-UAPA your principal district judge has?
That note is not data note.
Then,
That is
sir,
correct.
That is what.
That is not, we have to take up note, how many under trials are there?
Conscious of
Who are
the
in custody?
workload of a principal district judge?
On a day,
Not exclusive, no, it is not exclusive.
suppose if he is to list a murder trial also on that day, few family
But
court
anyway.
appeals also, civil appeals also, MACT also.
Not exclusive to you.
SC Act also, this and that also. The two matters, you NIA or your UPA matters. Morning, the lawyer will seek an adjournment, he will grant adjournment, will remain busy with the other matter. That is not going to serve the purpose. That is the reason. All of you today, you need not to, you see, this we wanted to sensitize you about this problem which you are facing. You are the best person now to tell us that how many cases of UAPA or same kind of some, a statute where, which defines really heinous crime. Say in Maharashtra, you have MPID.
Makoka.
Look, Sati is here.
20 NIA cases which are only municipal. No other district has NIA cases, and we have 5 courts. Out of it, one is exclusively NIA court. 4 are designated courts. Wherever there are cases, they take it, and only if there is no NIA matter, they do other work. Otherwise, there are 4 designated, 1 exclusive NIA.
What we are suggesting today is that you please furnish us a complete data of the cases. We were able to get the details from as far as NIA is concerned, because learned additional sources in
That order we are giving to the high courts, to the legislature.
to the high courts through the registrar general to furnish the data, but since you are the chief prosecutors, you are also aware of it. You furnish the data. Based upon that, we need to determine that how many exclusive dedicated courts are required state-wise. And this figure will vary from state to state. Jharkhand has its own unique problems. There might be facing UAPA cases much more, much more than other states. There might not be even 20 cases in other states. We are not sure about some of the advocates are there online, so like in, but there are other matters like in Maharashtra, the Makoka, Mr. Trivedi is there in Gujarat, you have Gangsters Act. In other states also, this kind of acts are there, where there are very stringent conditions of bail, and which bail is normally not granted. This ecosystem or this mechanism which we are evolving is only meant to deal with exclusively. We are using the word exclusively. No other case to be given to those guys. And please, in Jharkhand also, this in fact the policy will have to be changed. And never give to a principal district judge. He has a lot of administrative work. He has to assign.
Even other cases also.
It will take you only to assign cases to other courts.
You can think of not creating exclusive court for UAPA also.
Most additional sessions can be there. Another additional sessions can be there who has paid 5 to 7.
Like for notes, NIA, we have given one additional session just exclusively for NIA cases. So we can think about that in UAPA matters also.
So all of you can now furnish the details of the cases pending, and then broadly, what it appears to us tentatively, subjective analysis. For every 10 to 12 or maybe maximum 10 to 15 cases, you need one court. Reason being, please see the timeline of 1 year. If you have 200 witnesses, 100 witnesses, 300 witnesses to be examined in one trial, see the practical part also. And after all, the presiding officer is also a human being. How much work we can expect? 15 trial multiplied by the total witnesses he is supposed to expected to examine. Then you see that whether he will be able to decide. Then arguments also, judgments also will have to deliver. So within 1 year, if you have in between sometimes vacations, all this part, if you add all discounts, and then you see that how many trials can be concluded in 1 year. Because we have to change even the criteria of annual confidential report evaluation of those officers. They will not earn the credits or the units as you call.
Has come in the last order, my doctor.
With the last order.
You have mentioned it last time.
Yes.
Disposals will not be there. Disposals.
Another thing for you is the dedicated public prosecutor. Now you will have to maybe that you can't make recruitment through public service commissions or any, but then in consultation with the Chief Justice of the High Court, you invoke that corresponding provision 24(8) or whatever it is. And please, you will have to notify the public prosecutors for that. That is another
For a
responsibility.
special prosecutor, my lord, we need not consult Honorable Chief Justice. Even
No.
after 24.
You can do it.
CRPC state can do it.
But sir, the only thing is the workload of the public prosecutor.
That's right.
If you have one public prosecutor.
That's why in our
for
order,
50 cases,
we have used the word dedicated.
Dedicated
This is the
public
order dated.
Yes.
This is the
Lordship,
last
but
order.
I have one,
24th
I have
March.
one request
24th
to make.
March, paragraph 13.
Lordship, I have one request to make. NIA is providing us financial support. Likewise, NDPS also.
Yes, my lord. Yes.
We are working on that.
We have filed a affidavit that in same terms, we are also going to do it, my lord. It is for financial concurrence, my lord, so it will be soon done.
Whatever may be the special courts which are to be deal with, which will be dealing with the exclusive matters, we have an assurance on record, and the central government has come up with a very positive approach on this issue, that they will provide you the necessary funding for most importantly, you require recurring expenditure.
Yes.
Because that is the real burden, and that they are happily agreeable. Also, but probably we are quite sure that you have made it clear. Like UAPA cases,
Yes, Manoj.
very few cases being tried by NIA,
Yes,
or
Manoj.
maybe many cases by them, but some are being tried by the state prosecutors.
Yes, Manoj.
You will provide this recurring expenditure even for those cases also.
Manoj, right now the decision is not there, but I will persuade Manoj.
I think that
I'll
is
persuade
also.
Manoj. We'll persuade. We are grateful that your lordships, Manoj, are investing so much of energy and effort into this. This is the best way for the nation, Manoj. After all, these victims also need Manoj justice in a timely manner.
See, this is some, there is no other way out for balancing the rights on both sides.
Yes.
Otherwise, there are matters right now, today we dealt with the, These are very serious challenges before the courts also.
But Madam, see, if you make a parallel,
Yes,
NDPS, there are 3 or 4 agencies. The NCP is a central agency.
Lordships.
But state agencies also investigate and file before the special court.
Please, madam.
Now, if the central government in its project for NDPS is providing funds for special courts for NDPS cases,
Yes, madam.
it is statute-specific funding.
Yes,
And
madam.
if you can make UAPA statute-specific funding,
Yes, madam.
so the funds can be used both for the NIA as well as state prosecutions of UAPA cases.
Well, the present proposal is only
No,
for NIA,
that
but
is
I
why-
will.
That is why we
Yes,
are giving you a suggestion.
I'm grateful.
Please take the model of NDPS.
Please, madam.
In NDPS, the special court deals with both state and central government.
Yes.
Yes, madam.
Now, if your funding scheme
Yes, madam.
includes addresses, not NIA,
Yes.
but addresses UAPA, then you can fund both the prosecution.
Please, madam.
You can make a little bit of a tweaking.
Please,
there.
madam.
In fact, my lords, once a case is transferred to NIA, then it comes under the central government. Even the public prosecutor is appointed by the central government. Your lordship. But in other cases, UAPA, it's a, my lord, investigation is made by the state agencies, my lord.
Exactly.
So perhaps that is the reason that so far NIA is concerned, my learned colleague had.
No, we are fully conscious.
Lordship.
But this logic has evolved because the UAPA Act speaks of 2 sorts of courts. One court set up by the central government, one court set up by the state government. This situation is not prevailing in NDPS Act, right? There it is a special court per se.
Lordship.
It's the state which appoints. Now, your government is funding those special courts instituted by the state. So by incorporating that logic in the UAPA proposal, if Madam Aishwarya's notification addresses not NIA Act, but addresses UAPA Act, may help in proliferation of the courts, and that can have a beneficial impact across the board, irrespective of whether the NIA prosecutes or the state prosecutes.
Same analogy, my lord, like in NDPS, my lord, now there may be different investigating agencies like NCB, DRI.
They file their reports before one court.
Yes.
That is the special court.
Your lordships.
But in UAPA, read with NIA Act, the
Different.
NIA prosecution goes to the central government court.
Yes.
Whereas the state prosecution goes to the state.
Well, I'll come back. I've understood.
This is why we are requesting Madam Aishwarya to make a little change in the notification, not to address NIA Act, but address UAPA Act.
Exactly.
That way the umbrella will be
Your lordships.
wide.
I've understood, madam. I'll come back on this. I'll come back on this.
Right down. So in reference to the order dated 24th March.
As far as the state of Mizoram is concerned, there are no UAPA. But there are 5 NIA cases pending. And we have designated the district court of Aizawl for that particular purpose. But NDPS cases are there, quite a lot. And that's why there are 3 excessive.
See, in a state where UAPA cases are far less, as I mean, for the purpose of say entrustment to a court to work exclusively for that purpose, that court then can be assigned some NDPS cases. So, for example, suppose we take a benchmark of 15 cases, but you have only 5 UAPA cases. That court can be given 10 NDPS cases. But let it remain an exclusive court for this. If you have even 5 cases, but there are other 100 of cases given to that very court, we are only illustratively we are saying, it becomes difficult even to conclude those facts. That is what the challenge we are facing everywhere. So in reference to the order dated 24th March 2026, Learned Advocate General for the states of so-and-so, so-and-so, so-and-so are present in person, whereas the other remaining Advocate Generals have joined online. That's correct. The issue pertains to.
So now in another 40 minutes, the case will be
establishment of exclusive special courts for the trial of UAPA cases by National Investigative Agency or by the state police, as also for the trial of NDPS cases by different state and central agencies. Pursuant to the order dated 10th February 2026, it was brought to our notice, the Learned Judicial Association of India placed on record the office memorandum dated 7/1/2026, which has been reproduced in extenso in our order of 24th March 2026. In terms thereof, next paragraph, very briefly, in terms of the said office memorandum, the Union of India has agreed to reimburse the non-recurring expenditure of 1 crore to all the state governments, provided that the cost of land or the cost of construction for establishment of such special exclusive courts is borne by the state government. The Union of India has also agreed to provide a sum of this 1 crore as recurring expenditure, as annual recurring expenditure for the establishment of such courts, along with the requisite staff, a brief detail of which is fine mentioned in para 2 of our order dated 24th March 2026. That's right. Since the above stated order, it was also pointed out by Land Additional Sources on that there are 17 states where more than 10 trials under UAPA being conducted by NIA are pending. In addition to the trials under UAPA which are being conducted by the state police. It is in this backdrop that this court deemed it appropriate to request the Learned Judicial General to remain present to appear
Infrastructure.
for the purpose of -1I to identify as to how many separate exclusive NIA/UAPA courts are required to be established for conducting the trials in all such cases under UAPA, trial in UAPA cases, whether the trial is conducted by NIA or the state police. 2I, the appointment of dedicated public prosecutors at each such court. 3I, the provision of requisite infrastructure for establishment of such exclusive courts. Next paragraph. We have briefly had Advocate General on these issues. It seems to us on these issues, we have impressed upon them to secure complete details of the trials pending under 1A UAPA, whether conducted by NIA or the state police, and 2, under the NDPS Act, whether such trials are also conducted by the state police or the Narcotic Control Bureau, etc. Next paragraph. Upon receipt of this information, a uniform yardstick can be evolved in order to determine as to how many exclusive courts to deal with UAPA stroke NDPA cases, NDPS cases are required to be established in each state. Next paragraph. It goes without saying that to give effect to the Office Memorandum dated 7/1/2026 issued by Union of India at the instance of this court, it would be necessary for the respective states to provide the requisite courtroom and other infrastructure for establishment of these exclusive courts. They shall also have to appoint the special public prosecutors, special public prosecutors for each court. For each court, in bracket for the state cases. Similarly, Union of India shall appoint the special public prosecutors for the cases conducted by NIA. Next paragraph. The state governments in consultation with high courts will also require to make additions in the cadre strength of their respective higher judicial services to the extent of a requirement of establishment of exclusive courts. So, the courts shall be presided over by the judicial officers, preferably having experience of 5 years in conducting sessions trials. Next paragraph. One more issue that has kept in is whether the central government will provide financial assistance of ₹1 crore incurring expenditure even for those special courts where cases under UAPA or NDPS Acts are being conducted by the state agencies. So, since the
1 crore for infrastructure
One
also.
each.
1 crore for each.
1 crore each.
Each court.
Each.
1 crore,
1 crore for
1
infrastructure.
crore
and
for
1 crore
each such
for
court,
recreation.
where the cases are being conducted by the state police, state agency.
Well, let me say 1 plus 1 crore because it's one record.
Oh, one plus 1 crore shall be provided. That's right. 1 plus 1 crore for each court shall be provided. Since the office memorandum dated 7/1/2026 does not expressly clarify it, Learned Edition Sources Journal of India seeks time to seeks and granted time to have clarification in this regard. Will you be able to find out within 2 weeks or so this information?
Should not be a problem. Should be able to.
Not be.
India will provide assistance, financial assistance for conducting all trials under UAPA stroke NDPS Act within the timeline of 1 year
25.
as earlier indicated by this court. Notwithstanding the fact that such trial is being conducted by the central agencies or the state police. Next paragraph. Plan Advocate General seek and are granted 2 weeks time to have the requisite information. Meanwhile, the Registrar General of the High Courts may also be asked to provide the information as per para 11 of the order dated 24th March 2026. Post this matter for further consideration on so date. We will request all of you to come here.
Yesterday,
Even-
my lord,
Even those who are online, next time, Mr. Trivedi, we will request all of you and you please do come to.
yesterday, my lords, we had.
I have a submission.
It will be my privilege, my lord.
Your physical presence makes it's more meaningful than your online appearance.
My lords, I should be there.
Your Lordship obliged us by having it on a
Kind
Monday. Your Lordship obliged us by having it on a Monday, so we had the benefit of a dinner in the Solicitor General's house. last night. All the Advocate Generals met.
Lord, I have a submission, my lord. So for Orissa is concerned, we have around 8,000 plus NDPS cases. We had given a proposal to the Honorable High Court for setting up of 10 special courts for NDPS. The High Court has given a proposal for 19 courts in different districts out of, we have 30 districts. So that data was not available with the union government.
Actually, it has not come in the affidavit.
Sure, I will file it. Your Lordship may notice, we are accepting notice on behalf of the state. So your Lordship may record it. I'll furnish the data by shape of affidavit on the next stage.
We have already said, Usmai line.
We have filed our affidavit, my lord. So far as NDPS cases are concerned.
NDPS is included.
NDPS cases
Yes,
are concerned.
only the
we have filed
NDPS.
our affidavit, not
We have
filed
only-
Today, there is a meeting held under the chairmanship of Home Secretary with all the registrar generals and senior officers. my lord. Today is the date for that.
Right, right.
And they will be identifying the total need. One meeting already held on 5th December. Today is another meeting being held. And my lord, so far as financial concurrence is concerned, that is also being considered after the discussion with all those. So that how many number of courts with respect to trial of NDPS cases, my lords, not only in which the central agencies are investigating, but also the state agency, which has fallen from my lords, my lord, is being considered. So your lordship may consider our affidavit,
Yes.
my lord, that it is, we
That's
have filed our affidavit. That
In the previous order, my lord, it was reflected in para 15 and 16. Your Lordship may reiterate.
Yeah, will also file a status report with respect to the decision to be taken by it regarding providing financial assistance for establishment of exclusive courts for conducting cases under the NDPS Act. Under the NDPS.
But paragraph 11 doesn't mention NDPS. Paragraph 11.
No, para 15 means.
Does not include NDPS. You would kindly provide that the similar order will be there for
It is
NDPS.
clarified that in the previous orders, wherever the expression UAPA or NIA has been used, the same shall also be construed to include the UAPA cases being conducted by state police as well as NDPS cases conducted by the central or state agency.
That is what fell from your lordships on the last occasion, that that special court should not be a special court for many special offences or special acts. My lord, insofar as Telangana is concerned, my lord, the High Court and the state, there was a fourth additional district judge, my lord, who was the designated court under NIA. My lord, the court directed that that court shall deal only with NIA special cases, and all other special acts which it was dealing with, my lord, should be assigned to another court. So that fourth additional district court is now the special court for NIA alone. But that would
That's
be the
very
easiest.
good. That's very good. But, see, the High Courts doesn't have sufficient manpower. If you take out one officer, you do it at the cost of other legal.
Yes.
Then our problem arises then if in a family dispute, suppose a woman start crying saying that my maintenance application not being decided. So what is there? An MACT case and a person who has been unfortunately lost his life, his children are there waiting for, though it's a very not contentious matter, but then human value is involved. That is the whole predicament, that how to spare the officer. Then we thought that maybe this addition temporary or litigation in any case is increasing. And these cases, once we are able to say conclude within 1 year or next 1.5 years, let us say target, when courts are to be established, then they will become functional. After 1.5 years or so, you will not find this much crisis. Then it will be a manageable affair. then to the extent you can give additional work to the court. So that is what we are visualizing, that that's the only way out to deal with. But thank you very much that all of you have come. Take up on will it be fine if we take up on 4th May, Monday?
4th May. Please, Manoj.
Monday will prepare.
Manoj,
11th. All right, 11th.
one more suggestion, Manoj. Your lordships had issued notice only to the 17 states, Manoj, where the more than 10 NIA trials were there. Would it be your lordship's pleasure to issue notice now that your lordships are concerning the entire UAPA conspectus and the NDPS? Let notice go to Manoj all states, Manoj.
Very right. Since the state, since the cases under UAPA and NDPS, which are being conducted by the state agencies, are also proposed to be brought within the ambit and view of these proceedings. Come on, let notice be issued to the states other than mentioned in para so and so the order, and the Advocate General of these states may also be requested to be present in court on the next date of hearing. Then suppose this matter on 11th May, Monday.
What Lords may ask, suppose it on 4th May, my lord, for the reason that South Indian states, my lord, we have our vacations which start. 4th May would be better.
Can I request for 8th, madam?
4th or because we start.
Please, Manoj, that will be.
Yes.
Please.
Lord, 11th May is fine for everyone, I think.
When there are missed, there are 8 opinions.
11th May is
And you can point out this matter, then we'll take up at 11:30.
Please.
After taking up some urgent matter,
Ma'am.
at 11:30, maximum by 12, we will take up this.
Yes, ma'am.
Grateful.
8th is Friday now. So Monday and Friday both should be convenient.
We are looking for new host.
Many of us are here. Why are you searching? Yesterday, the Lord Solicitor General had hosted a dinner for all the ages.
Oh,
So
for them,
last
it's a good occasion for the.
Yes, now Aishwarya Bharti has been chosen.
Later in 3 of our states, the election results will be out also by 4th May.
Grateful, Milan.
Grateful.
Just winding up proceeding now quickly.
Grateful, Manoj.
Yes, this matter 42. Madam Aishwarya, probably you are there.
Manoj,
And Mr. Hariharan,
Please, my lord.
could you see the charge sheet?
Please, my lord.
Could you go
Yes,
to
my lord, the
charge
charge
sheet?
sheet, in fact, certain pages from pages 182 to 194 are completely blacked out. Both in the e-copy as well as the physical one which has come to me. Completely
something
black.
blacked out, I can give you.
Yes, I need to,
I'll give you.
but I don't know what exactly you have recorded there. If your lordship will see
I'll
the,
give you now, sir. We need not bother the.
I can't read a,
court with
I
this.
can't read a single line.
You take another copy.
Yes, your lordship needs.
Apart from that, the affidavit of one of the respondents is yet to come in.
I am
The other
appearing for
hospital.
respondent 3. We have filed our response yesterday morning itself, but it could not come into record because it was e-filing. I have a copy.
All right, you first give copy to Mr. Hariharan.
Please,
You
please.
take up then on Friday,
Very well, my lord.
and you take another copy.
I will take
Yes,
another.
Manoj, I'll do that.
Let me take a soft copy from.
I have got a soft copy. The soft
We
copy
have
is
already
also like.
Manoj, I'll sort it out, Manoj. I will
Take
sort.
up on Friday. Meanwhile, just give. copy.
Please.
Please, Manoj.
Say,
I'm so grateful.
We are informed that affidavit has been filed by so and so respondent also. The same is tagged with the paper book. A copy be given to the
This I already have.
office of launching of constitute.
It says Friday.
Grateful.
Please.
Friday.
Grateful.
The Aravali matter will be taken up on some other date.
Please,
because
Manoj.
It's a 3-judge bench matter.
Please, Manoj.
So in all fairness, it should go through.
Please, Manoj.
We'll take up on other date. And
My lords, there is this Haryana matter also, triple X, my lords. Would your lordships give us 10 more days? The SIT needs 10 more days to complete its investigation.
no issue.
Please, my lords. Grateful, my lords.
And that Jammu matter,
Yes, my lords, but if your lordships call it after 2 weeks, they'll shift into that, my lords. By April end, they are shifting into it.
it will take up after 4 weeks then.
Please, my lords.
I'm appearing in item number 18, your lordship.
Cannot, because we are three judge bench matter. We are giving a date. We are giving a date. We will list it.
Yield order me.
We have to spare one of my colleagues because of his scarcity.
Only requesting a short day.
Oh, it's not listed.
It's not listed.
My lords, the Haryana matter I have only mentioned out of.
Anyone in item 18 pass over.
I'm appearing in item 18, your lordship, for the petitioner. I have a humble request to make, your lordship. In item 18, the petitioner has passed away, your lordship. I just have to file a necessary application to substitute the petitioner. Additionally, your lordship, there is a change in council also, because there are certain more.
Don't file this kind of petition now. The High Court has taken care of everything.
Your lordship, there are certain things, all prayers are not taken into consideration. And your lordship, there are certain complaints.
No, don't indulge too much now. One issue that has been rightly in view of the categorical affidavit filed by the sub-divisional magistrate Thiog, just similar for the High Court, and the self-explanatory observation by the High Court also. We see no reason to. We are satisfied that no further action in the matter is called for.
Because item 53, item 53 is a matter of Mr. R.K. Das, retired judge of the High Court, for areas of pension. So I know today is after 2:30, the lordship can have it as high up on the board and someday.
No, is it, are the pleadings?
It's covered by the judgments of this court.
No. Are the pleadings complete?
Yes. Counter rejoinder have been filed. They have added 10 years of service, but they rely upon some order passed with regard to the higher judicial service in the All India Judges case.
Take all the judicial services we have matter. So they have granted pension to him. It's not that they have not granted.
It's only a question of giving the area some date of retirement.
And refixation.
In terms of the lordship judgment.
That one, because this will have to be on pan-India basis.
Yes.
We'll take up in those.
I wanted to just mention, my lord, the addition of 5 to 7 lakh new voters using Form F, my lords, in West Bengal. This is contrary to your lordship's order dated 13/4. My lords did not allow the addition.
Should have constituted a separate bench in Supreme Court.
But my lords, since your lordships are now that bench, my lords, please see this, my lords. Because your lordships never allowed the addition of new voters in this way, using Form 6. And this has now been done. Please.
File the petition. You will not see like this.
My lords,
File the petition.
we don't have enough information. The newspapers are reporting. Have an impact on the election.
We can't make a fishing inquiry, madam. If you digest it.
Your lordship's order is being used to allow these Form 6s to be filed in bulk. Your lordship's order dating 13/4 pertain to appellate tribunal.
Challenge something
was
before us.
intended to allow this.
Please challenge something before us. We will entertain.
No, if they release the final rolls, then we will be able to challenge it. But they've not done that. Your lordship, Justice Bagchi, specifically deprecated this practice by the Election Commission of allowing Form 6s. This has only happened in the state of West Bengal. It will have a outsized impact on the elections.
State of West Bengal, that's the whole problem.
Now this, my lords, with respect.
Please challenge, we will examine. We can't take the case like this.
When they haven't released the information, newspapers are reporting the additions of this.
Entertain like
My lord.